Perfect.
We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this video conference format because of the ongoing pandemic. Although we're conducting court in this fashion, all the ordinary rules of oral argument in our court apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of 2020 P1405, Commonwealth versus IRVIN Dominguez. And Attorney Liddy, we are ready whenever you are.
Thank you, Your Honor. May it please the court, Jean Liddy on behalf of IRVIN Dominguez. Your Honor, IRVIN Dominguez brings a claim for the court's consideration, which I would suggest is a very strong claim on his behalf. He is seeking the verdict to be set aside and the matter to be remanded to Superior Court based upon prosecutorial misconduct. The reason that the appellate says the claim is very strong is that prosecutorial misconduct sounds in a cumulative effect of errors that were highly prejudicial, egregious, and overwhelmed the case. I would start with the opening argument of the prosecutor. There were a number of errors.
I'm sorry to interrupt. This is the term prosecutorial misconduct is, I think, often used when prosecutors do something like destroy the evidence or not deliberately not produce documents or something like that. But here we're talking about your argument that there are errors in closing, in the closing and in the opening, right? Misstatements, resorts to improper rhetorical forms, things like that. Am I correct? Do we normally call that prosecutorial misconduct, or do we analyze that to determine, you know, in here, because there was no objection, don't we analyze that as an ordinary unpreserved claim of error?
Yes, it would be a risk of substantial miscarriage of justice, as the court points out. I would suggest, however, that not only was it only found in the opening and closing of the prosecutor, but throughout the introduction of testimony and evidence in the course of the trial. And standing alone, one of those things may not have been enough to rise to that standard. But I would suggest that there were so many of them that it overcame and encompassed the entire trial. And if I could start with the opening, and I'm sorry.
Yes. So I want to make sure there are many statements that you're challenging, but you have them grouped under two different headings. So the Commonwealth, each statement it thought you were challenging and gave it its own letter. And what I would like to know from you is, I don't want to have us overlook any argument. Did you feel that the Commonwealth got them all, or did it miss any? Because I just want to make sure we know the scope of the universe here.
That's a good question, Your Honor. Hold on a moment. I think I have a chart and I can focus that a bit for you. I think that the Commonwealth missed two of the officers in their testimony. But that was a really brief matter, and I would suggest that it was Palmer and Giordano. Giordano involved the license restrictions, and the jury heard it. It was sustained, but the evidence was heard by the jury. So our argument would be that that bell could not be unrung, and that would be one cog, one part of the entire piece of the puzzle. So again, that's very short and brief. And I believe the Commonwealth did address my argument paragraph by paragraph. But for clarification and for today's argument, rather than marching through each of them, I would suggest that it can be grouped more by theme and by broad brushstrokes.
Okay, but with Palmer, was there some particular statement that you are raising a concern about?
Yes, Palmer involves a incident where Mr. Dominguez was stopped 2 months before this event. And it involved character evidence. In other words, he had a bad license, he was stopped, and it wasn't really relevant or material to the trial.
What was the prosecutor's question?
The prosecutor asked if Mr. Dominguez had been stopped 2 months before for a license violation. And that was kind of unrung because it was sustained after the question was asked. But in addition, Giordano was asked about Mr. Dominguez's physical license restrictions, but he wasn't prepared to.
Was there any kind of pretrial motion seeking to exclude that evidence?
I don't believe there was, no.
Okay,
no.
so how was, is it your contention that the Commonwealth was required to seek a ruling before it asked that question?
I believe he should have, yes.
All right, so what would be your authority for that as a case?
I don't have one, Your Honor. I would ask that I could submit a letter and brief that more fully for the court's consideration.
Well, we won't take additional briefing.
Okay, I understand.
So, but in terms of a risk of miscarriage of justice, I know that at least some of the defendant's interview with the police was shown to the jury. Was it shown unredacted or were parts redacted?
I believe parts were redacted, and the court is referring to, I believe it's page 78 or 79 in volume 5. And that's a great point because Trooper, and I'm going to butcher the name, but I think it's Cabeceras, was one of the witnesses that the Commonwealth brought through. And that's the point where Irvin Dominguez is suggesting that that trooper's opinion of Mr. Dominguez being confused about the white image in his side mirror that was white. And then the trooper opined, well, the police, we know it was black. He had to have been confused because the motorcycle was white, that line of questioning. On page 78 in volume 5, the jury before that questioning did hear the 45-minute video. It's a little confusing from the transcript if it was redacted or not. I think there was representation that there was a redacted CD. However, they heard the questioning of Mr. Dominguez after Miranda was given to him. And I believe that the proffer by the defense was that Mr. Dominguez was confused because of a language barrier. Where we take exception is that the officer opined as to what he believed Mr. Dominguez was confused about. And our position is not only is the fact finder in the best position to judge the demeanor of Mr. Dominguez during the interview, but it really opened the door for improper testimony because Mr. Dominguez, the officer was opining as to what Mr. Dominguez was confused about. And he was opining what he was confused about because the officer knew the SUV was black and not white, and the motorcycle was white. And I believe that's been set forth in our brief regarding that issue.
So what I want to make sure is that you both agree that the record is crystal clear about what was and was not redacted from when the interview was played, and that we'll be able to figure that out.
Yes, I believe that the Commonwealth has, as part of its exhibit, used the video that was proffered to the jury at trial.
I want to, if I may, ask you to clarify in the context of assessing whether any of, let's just assume there were transgressions in the opening or closing. looking at whether they resulted in a substantial risk of a miscarriage of justice. And in that regard, I'd like you to help me make sure that my understanding of what were the actual live issues at trial. So I take it there's no dispute. It really wasn't disputed that the defendant was driving the truck that struck and killed the motorcyclist. Correct?
That's correct.
Right. So this is not an issue of identity or anything. So, or causation or any of those things.
No.
So in order for there to be a substantial risk of a miscarriage of justice from any of these items, what was the issue that was at play? Is it only a mental state?
Well, you know, he was driving a 26-foot long truck, he being Mr. Dominguez. He stopped on June 14th, 2018 at 6 in the morning on a busy 2-lane road to make a left turn. The motorcycle skidded, I believe, 57 feet and hit the back panel of the truck on the passenger side. And there's testimony, and also in the video that was presented to the jury, that the truck was noisy and rattling and making noise. And the issue is, what did he know at the time of the impact?
Right. So mental state.
Exactly. And I believe I've cited the Riho case. It's a relatively new case, October 1st, 2020. And I think that case is really important because it dovetails with what happened in the opening argument. On page 7 in that case, the court delves into discussing the judicial intent of the statute, knowingly colliding with a person and knowingly causing injury to a person. And that's on page 7. And they talk about daily too. And then on page...
Well, I'm confused. Which crime are we talking about now that you're requiring knowing collision?
Yes.
Because one of the crimes is simply negligence, and the other crime is knowingly leaving the scene. I thought we were talking about knowingly leaving the scene.
We are talking about knowingly leaving the scene, Your Honor, and negligence, but it goes to state of mind. And I would suggest that...
What's the state of mind required for the vehicular homicide conviction?
It's, hold on one moment, Your Honor, I want to quote the statute for the court's consideration. If I can have a moment. Whoever operates a motor vehicle upon any way or in any place to which the public has a right of access or upon any way and without stopping and making known his name, residence, and registration number and goes away to avoid prosecution or evade apprehension after knowingly colliding with, or otherwise
What that means is that he had to know that he collided.
Exactly.
Okay.
And I think that goes to the crux, Your Honor.
Isn't that the leaving the scene?
Yes.
Okay,
Yes.
so motor vehicle homicide, vehicular homicide.
I'm sorry, Your Honor.
That's just negligence, right?
Yes, correct.
Okay, so
Okay.
how does any of this go to negligence?
Well, because in the opening, are you focused on the case that I just cited or the opening argument? I want to make sure that
We've lost Mr. Kidd briefly. Maybe we ought wait a moment. Your time will not be affected. Hopefully briefly.
Sorry.
There we go.
Okay. All right, we'll add 20 seconds.
Thank you, Your Honor. I'm confused. So, is Your Honor asking me about the case?
No, so I think we
Okay.
already established that the only issue, really live issue at trial was mental state.
Correct.
So how do any of the issues that you've raised with respect to the opening and the closing result in a substantial risk of miscarriage of justice for the vehicular homicide conviction, which requires only a mental state of negligence?
Sure. Sure. Well, Your Honor, I believe that the prosecutor finished his opening argument with, there's only one reason he kept going. He knew, he left, he did it.
I know,
So,
but again, you keep going back to the leaving the scene. We're not asking about the leaving the scene.
well, he knew he caused an accident.
Again, it's negligence in operating his vehicle, right?
Right, Your Honor, but by the prosecutor suggesting what the defendant knew, and that he knew that he hit the car, and that he knew that the accident happened at the time.
But
And
for the,
also-
maybe I can put this another way. Doesn't for the homicide conviction, his knowledge before the events matter as opposed to after?
By
To
the-
determine whether he was operating negligently?
I'm not sure I understand your question. Do you mean before the impact? Is that what
Yeah.
Your Honor is asking? Okay, so there's conflicting testimony. There is the point where he made the turn. He saw something in his rear view that the police believed was black, but he thought, there was some question about that. There's question that he turned quickly, and there is conflicting information about how fast he was going. There's also information about his.
But where, I think Judge Wolohojian's question is simply, where does any of this error get you with respect to the negligent vehicular homicide? I mean, much of what you're talking about has to do with whether he knew that he had had an accident. That goes to the question of whether he left the scene.
Right.
What I mean, you have an eyewitness. She testifies as to what she saw, and certainly, I would think enough under Lanigan to establish negligence. Perhaps someone could wrestle with that, but you haven't raised that issue. How does the prosecutorial misconduct that you're raising, what particular aspects of the prosecutorial conduct that you're raising goes to the negligent vehicular homicide count?
I would suggest that one fatal error of the Commonwealth is that through their reconstructionist Ferris, there is no, I believe my time is up. Is that okay?
You can answer this question.
Okay, thank you very much. I believe that there's no information whatsoever that his report was admitted into evidence. And that would have certainly corroborated the negligence claim, because in that report, it talked about the dragging of the 11 feet. It also talked about how fast he was going with the sled that they used to measure it. So what we're left with is the prosecutor inserting his opinion, and through the testimony of lay people, what the moving parts were, no pun intended, in terms of how fast he was going and what actually occurred.
All right. Thank you very much. Your time has expired. Let me see if there are any further questions. All right. Thank you. Attorney Kidd, we'll hear
Yes,
from, we're ready for you now.
Yes, may it please the court. Your Honors, my name is Rob Kidd. I'm a prosecutor at the Bristol County DA's office. I represent the Commonwealth in this matter. The only way I know to respond is point by point. I just want to say in general, there was no prosecutorial misconduct here, but I'll start with I'll just start with the first issue, and unless the court has a direction and wants to point me in. I mean, there's.
Could I start you with where we just ended with the dragging 11 feet?
Yes.
I'm not clear there's that is in the record we have before us. Is that accident report in the record? Do you have someplace you can point us to?
No, the reconstruction report is not in evidence. Not part of the trial. There is an accident reconstruction report. It is in our office, and the report does say that the person was dragged 11 feet. I understand it's on file with the court, but not in this case.
Right. So I guess what I'm trying to understand is you've made an argument that the specificity of the statement dragged 11 feet suggests there was something in the record to support the prosecutor's statement, and then the evidence just didn't come in that way. Is that right?
Yes, it was an opening statement. I was being overly cautious in the sense that there's no trial record of the report. of that report. It is the center, as the court probably knows, that's the centerpiece of any kind of these trials. It's the most important report. And obviously the prosecutor would not have come up with that 11 feet.
Well, I mean,
out of thin air.
you know, counsel, so there are two problems and they cut in different directions, right? I mean, your argument is for me, about as weak as they come, in the sense of saying, oh, well, he would never have said it if he didn't have a good faith basis, where there's no evidence, there's nothing in the record that tells us he had a good faith basis. Now, part of the reason there's nothing in the record that says he had a good faith basis is because there was no objection at the time. So there was no reason to make a record about it. You know, that to me cuts both ways. I think sometimes it's rare, but sometimes prosecutors say things that they can't prove.
That's not the case here. Excuse me.
Well,
I'm sorry.
But we don't know that, right? Because what you're telling us about is something that's outside the record. But I freely give you the point that the reason it's outside the record is because there was no objection at the time. There was no reason to make a record.
That's correct. And that, yes.
Okay.
And that, if I may, Your Honor.
Sure.
So that brings up another point. I mean, again, I don't think it's a far-fetched. I really don't think it's a far-fetched inference to say that the prosecutor didn't pull 11 feet out of thin air, especially when defense counsel, as you just said, didn't object to that. Had he said that, and there would have been an objection, in my opinion, my experienced defense counsel, if the prosecution just came up with, just said he was pulled 11 feet and it was nowhere, it was not in the evidence. So I do not think, but anyway, as I said, what I should have done is supplemented the record with some sort of motion to expand the record to show the court that there absolutely was a basis to make this statement. But the point is, Your Honor, there's a plethora of case law that says that, in opening statements, it happens all the time. Things are said in opening statements that don't come out in evidence. That happens all the time.
So what's your best case on that?
I'd have to turn to my brief. It's which issue was that? We've got 11 issues here.
One of the first.
Okay. Okay, so that's page 27. If I may. Yes, I'm sorry, here it is on page 28 of my brief, Your Honor. The prosecutor could state in her opening statement anything she reasonably had in good faith expected to prove, absent a showing of bad faith or prejudice. The fact that certain evidence fails to materialize is not a ground for reversal. We need to not shift the burden to the Commonwealth. It is not our burden to show bad faith. It is the defendant's burden, and she has not shown that in this case. She has not shown that there was no good faith basis for this, and I think I've produced.
Well, she's probably shown, let's just say, a lot of skating close to the line. Why don't we take the very first sentence of the prosecutor's opening? The peanut butter and jelly comment. To what element of either charge that the Commonwealth was seeking to prove did that go?
It doesn't go. It's an opening statement, Your Honor. The opening statement
is not supposed to be argument. So
no.
It's supposed to be sort of a roadmap of what the evidence will be. But I'm asking you something else. Can we agree that it doesn't go to any element of either crime?
We can, as does a lot of an opening statement, Your Honor.
All right. And so to what does this go? I take it you're saying it goes to humanizing the victim.
Yes.
All right. So in the context of a motor vehicle homicide case, have we ever held that it's proper to, or that this concept of humanizing the victim is relevant or admissible evidence?
I don't have a specific motor vehicle homicide case.
Okay,
I don't know if
why
it's
would that be relevant?
relevant to what? Humanizing the victim? It is relevant
Why
to
would that
humanizing
be
the-
relevant to a case where the charges are vehicular homicide and leaving the scene of an accident? Would either of those charges depend on whether the victim was a good person, had had a peanut butter and jelly sandwich made for them by their wife in the morning, or had left the home and was a terrible person and, you know, no one makes lunch for them in the morning?
No, Your Honor, nor is the
Okay.
fact that it was a beautiful sunny day and the fact that
Well,
I can name
actually, the
100 facts that
beautiful
are not-
sunny day might be relevant because it would go to negligence, right? If it's
Yes,
right.
I'll give you that. Yes.
Yes. So again, I'm asking you, how was it relevant
To what, Your Honor? To an element of the case?
to anything? If
Your Honor, it's,
humanizing the victim, if humanizing the victim is not relevant, then how does this become relevant?
Humanizing the victim is absolutely relevant, Your Honor. I didn't say that that's not the case. It is absolutely relevant. He has a right to humanize the victim. I've cited a case in which
Was it a vehicular homicide case?
No, but I don't see that. If the court could inform me, what is the distinction
What
between?
kind of case was it? That
I think it was, I believe it was a homicide, Your Honor. Regular, intentional homicide.
I mean, the cases suggest, I think, don't they, counsel, that the juries, at least, you're allowed to talk to the jury a little bit about who it is who died.
Yes.
And where they came from and what they did that day, in order to provide context for how they happened to be on a road at 6 o'clock in the morning.
Yes. Yes. And I did point out in the brief that you need to look at the statement in the context of the entire
I
opening.
mean, look, you know, the next sentence is, she didn't know that it was the last time that she would see him again. Now, what the wife knew or didn't know is clearly just an effort to tug at the jurors' heartstrings.
Yes. Well, no.
I mean, a much better sentence would simply have been, she didn't see him alive again.
It sounds, yes, it's a little bit different, I guess. But I'll say that
More
the
than
case
a
that I
little bit
cited, that's
different,
exactly
because
what
it's
was
not
said
about
in
the state of
homicide
mind
case.
of someone other than the victim, which is what that sentence is about, the way it's framed.
And that came in without objection, I would point out. And I would also point out that the homicide case that I quoted, I need to find, if you just give me a second. 25, I've got 1 minute. Yeah, yes, Your Honor. On page 27 of my brief, there's this case, a quote from that morning that they came to open the store. They had no idea that within a few short hours that day, that normal Sunday morning, a morning not unlike any morning they had come to open the store, would turn into the family's worst nightmare. Within a few short hours, the victim's husband would lose his wife, the children would lose their mother, and the victim would lose her life. So I'm not sure I understand what this distinction is between a homicide case and this. I understand, I guess it's an intentional act.
Right, it's
And
not
an intentional act.
negligence.
But it is still an act that is the fault of the defendant and is the right of the Commonwealth to humanize the defendant. I mean,
Humanize
yes.
the victim.
I mean, the victim. Yes, yes. So I'm very comfortable with what the prosecutor said personally. I don't think it was out of bounds at all.
All right, so assume that we see that some of the aspects of the opening went over the line.
Okay.
Do you want to address the question of substantial risk?
Sure. I mean, yes, you just need to look at the evidence of the trial as a whole And I would suggest that there was substantial compelling evidence that the defendant was guilty of leaving the scene of an accident knowingly, causing death. And I think that is really the only issue that's raised in the brief. Now, the defendant, just to briefly go through it, the defendant takes a quick left-hand turn in front of the oncoming motorcycle. He doesn't use his blinker according to the witness. He goes into the complex. He leaves a different direction. He goes a circuitous route to get back on the highway. He goes back to the parking lot, and instead of meeting with his boss at the truck, he leaves the truck there, goes to meet his boss. The boss doesn't say anything about it. There's a subsequent interview when he essentially denies that he had any knowledge that the motorcycle hit him. And then during the course of the interview, he actually says that, yes, I may have thought that I hit something and I was afraid and I left, words to that effect. And that is the line that the prosecutor used in his first line of his opening. He quoted from the defendant's interview. I think the evidence is summed up in the facts section of my brief. Again, I think there's ample
It's actually,
evidence.
I don't think the first line of the Commonwealth's, of the prosecutor's closing are words that the defendant said, correct?
Yes, they
They're
are.
words that the police officer said during
Yes.
the interview, and then the defendant appeared to have adopted.
Yeah, yes, there were
Okay,
quotes from the interview. Yes,
Yeah,
fair enough.
Accuracy is important.
Yes, it is.
So counsel, I guess my question is, let's assume for the moment that he did not know that he in fact had collided with the motorcycle. Okay, I know you're gonna say that's not this case, and that's fine, I understand that. But if he then drives by the scene with his boss, or say he returned to the scene in a different vehicle, can he be found criminally responsible for not then saying, oh my gosh, maybe this was me?
Yeah, so the question you're asking is, can he be found guilty because of learning after the fact that he had hit the vehicle? If that's the question.
And then not coming forward.
Yes, I researched that and I said it in my brief. There are no cases that answer that specific question. There are no cases. The Rijo case that Attorney Liddy cited, the facts in that did not involve subsequent discovery of the accident. It's not applicable. All I can say is that it would seem to be against public policy and common sense to say that it's not a crime to leave someone dying in the road and discover it later and not say anything. It certainly seems to me.
The crime is defined as knowingly leaving the scene. I mean, what you're arguing is maybe they should have a different statute. Seems to me. I mean, the element is he has to know that he's leaving the scene, not that he learns later that he had left the scene.
That's the way the statute is written, yes. And there are no cases that interpret it, but there are no cases on point with respect to subsequent discovery. So.
And the crime of negligent homicide is not, someone can still be guilty of a negligent homicide even if the victim was more than 50% at fault for the accident.
Yeah, I think so. I'll be honest. I didn't really research that because it's not part of the defendant's brief. But I believe that's what the jury instruction says.
Yeah, I think it does too. Okay.
Yeah.
Let me check to see if there are any further questions. Thank you both. It's an interesting.
We are live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format because of the ongoing pandemic. However, all the ordinary rules of oral argument in our court apply, including that each side receives 15 minutes to argue with no rebuttal. I'm going to now call the case of 2021 P0348, Commonwealth versus Arthur Salisbury Jr. And we're ready whenever you are, Attorney Campbell.
Good morning. May it please the court. My name is Alan Campbell, and it's my privilege to represent Arthur Salisbury Jr. in this appeal. Mr. Salisbury's rights to a fair trial were violated when the judge erroneously refused to strike 12 jurors for cause or to inquire of them further. Mr. Salisbury did not have enough peremptory challenges to remove all of them from the jury, and he was left with jurors he was unsatisfied with.
Did the defendant exhaust all of his peremptory challenges by the time the jury were seated?
He did, Your Honor. After he objected to the 13 jurors, the judge removed one of them. There were 12 left. The Commonwealth removed one of them. The judge, Mr. Salisbury, used his 7 remaining peremptory challenges. And as a result, 4 of the jurors that he had challenged were sat on the jury.
So counsel,
Yes.
counsel, the Commonwealth argues that the false reporting rate for rape is consistent with the false reporting rate for all crimes and is roughly 2%. I guess I'm wondering if you are disputing that factual contention or arguing we can't consider that.
Well, as a factual contention, you can't bring in new facts on appeal, so you wouldn't consider that. But regardless of whether or not it's consistent, the question isn't whether or not what the likelihood of a false report is in general. What the jurors have to determine was whether this particular individual was telling the truth or not. And when you have jurors
You get to ask a question of the jury now that we've adopted this procedure that allows lawyers to ask questions to the jury. You are allowed to ask questions to the jury. You know, what do you think generally about whether this happens? And the jurors give an answer that doesn't indicate that they are inflexible. It's simply an answer as to their sort of life experience with probabilities. Why isn't that perfectly fine? Because it seems to me that the opposite, what you're arguing, is really problematic, because it's suggesting that jurors can't come in with life experiences.
That's not at all what I'm saying. And I'm not saying that these jurors all needed to be removed, that nothing they could have said would have, that they were disqualified. What, to use the judge's word, in the first instance, it raises a specter of bias when you have these 2 statements. I believe false accusations in sexual abuse cases are very rare. And also—
What do you mean by bias, counsel? I
was trying to answer that.
The absolute core of your argument. I'm sorry.
The bias comes from a combination of these 2 statements. I don't think sexual assault victims make false accusations very frequently. It's very rare that it happens. Combined with the second statement, if a person makes an accusation and puts themselves through a trial, they are very likely telling the truth. That is a categorical decision that sexual abuse victims are more likely to—
Absolutely not, counsel. It is not categorical. That, I think, is, I don't see how you can argue that. They say rare or likely. Those are not categorical statements. The juror who made a categorical statement was removed from the jury.
Your Honor, I would say that even if it's not, perhaps I'm not being clear on this, it didn't mean that they automatically had to be struck. It raised the possibility of partiality, which needed to be explored further. Even the Commonwealth agreed at trial, we need more information on this, and the judge did not do that. What the judge could have asked a simple question, because he'd already, so you've given these things, you ask them, okay, despite those beliefs, are you able to listen to the evidence and decide it fairly? decided based on the evidence presented here, not based on the percentages you come in with. Obviously, people come in with all sorts of beliefs and opinions.
Did the judge not ask a question of the jurors whether they were able to assess the evidence in this case?
They did ask a question early on before the voir dire, but this information, after they had answered they could be impartial, raised a question of partiality. And the Commonwealth's argument based on Mahoney, which I can distinguish in a second, that just simply the fact that they had said they couldn't be biased and therefore cannot be enough. Because in that case, in almost every case, the judge asks, is there any reason that you have a prejudice or you can't decide this case? What if a juror subsequent to that said, say you have an African-American defendant, and the juror says, as in Clark, that I believe African-Americans are more likely to commit crimes. According to the Commonwealth's interpretation of Mahoney, that would be a perfectly fine juror because they had previously said they wouldn't be biased. When they present, did I interrupt the judge? No. When they're presented with new information that suggests partiality under August and Rios, the judge has a duty to inquire further. The Commonwealth agreed at trial that the judge had a duty to inquire further. For whatever reason, the judge decided, I'm not doing that.
Well, I mean,
The judge saw the veneer's individual was able to assess the answers in a way that we can't.
Yes, but you can read the record and you do have these statements. And I don't like to rely on unpublished cases, but in Noel, an unpublished decision in which this court actually rejected a challenge, the notable language was in a footnote, this court says, well, it's not like they made a statement of bias, such as sexual assault victims are more or less likely to be truthful than other victims. And in this case, we have the jurors indicating at least the possibility that sexual assault victims are more likely to be truthful because of a combination of it's unlikely that they're making false accusations, and two, if they put themselves through a trial, they're likely telling the truth. The only difficulty from that, without additional questioning, is that they believe sexual assault victims are more truthful.
But so that is a what's the best way to describe it? It's not an opinion. It's a perspective that juror brings to the courtroom based on their life experiences. As Judge Henry points out, it may be accurate. I don't think we have to resolve that. I understand. So you started your argument by saying they all should have been excused. You've moved to the secondary point, which was raised at the veneer, which is at the very least, the judge had an obligation to inquire further, and that the failure to inquire further means that we have to have a new trial. And that's why I asked you the question right off the top, what do you mean by bias? And I think what you're saying now is you mean partiality to one side or the other, evidenced by the answer, right?
Yes, but I did actually raise this in my brief, and I cited August and Rios for the proposition that
I understand you raised it in the brief. I understand you raised it in the brief.
Okay.
So Judge Wolohojian's put her finger on what I think is the difficulty with the second level argument that you make, which is cold record. You got to, and you've got cases that say, I believe basically this is sort of the last place that you're going to find an appellate court inclined to overturn a jury verdict is in a situation where the argument is the juror was allowed to sit by the judge incorrectly after voir dire. Here you have the judges who are seeing the jurors. They've had the jurors individually. The jurors have said to them, each of these four jurors have said to the judge, I believe I can be impartial given the facts that you've told me about the case thus far. And then you have these two answers that come in lawyer directed voir dire, and you say, oh, well, wait a second, that's no good. Now we have a basis to overturn the verdict. And well, it's problematic, isn't it?
It's not as problematic as Your Honor makes it sound. because the judge had the opportunity to very simply resolve this at trial. It's not like I'm raising this for the first time on appeal. This is what the judge should have done. Defense counsel said, these answers are very troubling, Your Honor. I'm moving to strike them for cause or to inquire further. The Commonwealth says, well, we don't need to strike them all, but I agree, we have to inquire further. And then the judge doesn't spend 5 minutes, 10 minutes in a case where the defendant is on essentially a capital case. He was for aggravated rape. The potential penalty was life in prison. The judge doesn't spend those 5 minutes. So it's not really a cold record. We have this as a live issue at trial that both sides agreed needed to be explored. And the judge just decided to ignore their duty under August and Rio to meaningfully inquire when presented with evidence that suggests partiality. I'm not saying that they all had to be, and the only possible resolution was removing all of these jurors, but the judge needed to inquire further. It's that simple. There is.
And your best case for
tough-
setting, what is your best case for setting aside a verdict where the error is the failure of the judge to inquire further?
I believe it's August, which coincidentally is the first appeal that I worked on, the first case that I worked on as a law student. That's the case. It was sent back.
Is that the Cambodian case or the race case?
Excuse me?
Is that the Cambodian case or the race case? There are two cases, right? Each one of them involves categorical, either ethnic or race-based statement.
Well, there were several. There was Clark, which is somebody said that African Americans, based on economic circumstances, were more likely to commit crimes. Long is the cases where somebody testified they were more likely to believe a police officer than a civilian witness. But August, back in 90 or 92, is the first case, I think, that actually set out, no, Judge, you actually have a duty to meaningfully inquire.
That's the Cambodian, that's the statement about Cambodians.
My notes actually didn't specifically break it down by race, so I don't know if it's the Cambodian case that Your Honor is asking about. That might be Summers, another case where it was reversed. But there are several cases where this court has in fact reversed on voir dire despite the difficult standard. And I agree it's a difficult standard, but we've met that because we have clear statements that the jurors could potentially decide a case based on categorical beliefs rather than the facts of the case.
Go ahead, Judge Henry.
Your argument has these two legs, one of which is the jurors said that they believed that false reports of sexual abuse were rare or infrequent. Are you challenging that belief as incorrect?
I don't know that it's relevant or not, whether or not.
Well, do we have to agree with you that that is wrong to rule in your client's favor?
You do not. You do not, because it's the combination. I mean, it may very well be true universally that that's the case, but what is a universal truth has no bearing on whether the jurors are going to listen to the evidence in this case and decide whether this sexual assault victim is telling the truth or not, or alleged victim is telling the truth or not. It could be 1 in a million raise false accusations. That is completely irrelevant to Mr. SALSBURY, because Mr. SALSBURY is saying, this one is the 1 in a million. Are you able?
People all also said they would listen to the evidence and decide the case based on the evidence of the law the judge provided, correct?
They did say that as well, but that was before they said that if somebody comes and puts themselves through trial, they're more likely to be telling the truth. That is another categorical thing, which has actually nothing to do with truthfulness.
Well, I think what Judge Henry is sort of getting to is, let's say, this may not be a very good hypothetical, but let's say, or analogy, let's say you ask in voir dire, do you believe in the mechanics of gravity? And the witnesses say, yes, I believe that, in the mechanics of gravity, that when someone drops something, it will fall to the ground. And then the testimony comes out and someone says, I dropped something and it fell to the ground. Do we look at the veneer person's answer to the question as indication of bias, or simply of common understanding that people have about things that they're entitled to use while assessing credibility of a witness?
I don't think Your Honor's hypothetical is an accurate comparison, because the laws of gravity are not subject to trial. They are objective, verifiable facts. Whether or not somebody has
Fortunately,
made a
we've
false
found over the
accusation
last
is not.
year that scientific pronouncements are apparently subject to lots of disagreement. But I do understand. I take your differentiation, counsel.
If I could just spend 30 seconds to give a hypothetical that I think is actually closer to these facts, and that would be, if you actually look at socioeconomic standards and use convictions as a proxy for having committed crimes, you could come up with statistics that show that African Americans from a lower socioeconomic standards are in fact more likely to be convicted of crime. That is a more apt one, because I guarantee that this court would not accept a juror who in a trial of an African American defendant said, I believe that African Americans are more likely to commit crime, even if they said that after they had said they wouldn't be biased.
I think anytime you go to those types of hypotheticals, you've moved a long way from what's going on in this case.
Not entirely, because Clark is one of the cases I rely on, and that's what the juror said, and they were struck. And if you go back and look at,
but you know, as much as you reject Judge Wolohojian's analogy, I reject yours, because it's a race-based analogy, and this case is not about race.
Clarify, mine isn't a hypothetical. In Clark, this court reversed because a juror said, I believe African Americans are more likely to commit crimes based on economic circumstances. That's actually the law of this state. You cannot say that. It's not a hypothetical. And similarly, I would say, at a minimum, when you say rape victims or sexual assault victims are more likely to be telling the truth, and that if you come and testify, you're more likely to be telling the truth, at a minimum, you have to inquire further of that juror before allowing them to sit on the
Judge Wolohojian, you're on mute.
Thank you, Judge Englander. We have your argument. I'm going to check, and your time has expired. I'm going to check to see if there are any further questions. All right. Thank you very much, Attorney Campbell. Attorney Townsend, we'll hear from you now.
Thank you, Your Honor. Thomas Townsend for the Commonwealth. The experienced Superior Court judge here screened the jurors, not only collectively, which he did. He asked whether there was any bias or prejudice that would have toward either to the defendant or the prosecution, but individually. He asked a series of questions, including, is there any reason you could not serve as a juror? Granted, that's a general question.
Well, but
he got more specific. Sorry, Your Honor?
Let's just go right to Clark.
Sure.
Why is this case different?
Well, in Attorney Campbell's hypothetical based on Clark, he said that statistics would be available to show that African Americans are more likely to be convicted of crimes. And then he fell back on the Clark case, where it had to do with a juror's perception that African Americans are more likely to commit crimes. There's a world of difference between the commission of crime and the conviction for a crime. The conviction of a crime, I think, would be easy to compile statistics. The commission of a crime would be very difficult, because you have other factors that are more elusive, such as systemic racism in the criminal justice system. So you can't take the conviction and draw an analogy saying, well, they're more likely to commit crimes. That was Clark. Here is different. Here we have empirical evidence. It's almost common knowledge that false accusations of rape are rare. The Supreme Judicial Court itself, in the King decision, cited the Department of Justice statistics that about 2%, which is equivalent, or roughly equivalent, to other violent crimes. That 2%, I think we can all agree, is rare. So what the jurors were shown here was not something far out, not some sort of opinion. I think the Superior Court judge referred to it as—
How does that though bear on the jury's job of assessing the evidence to determine whether the Commonwealth met its burden of proof beyond a reasonable doubt?
Well, I agree. I don't think it's terribly relevant. This was a question, both sides asked a question along the same line. Defense counsel asked, followed up on it and cited rarity or frequency, and then did another question: would a victim be more likely to be telling the truth, put themselves through?
But I think maybe this is analogous to a question that says, do you think police officers are more likely to tell the truth than not? Or do you think police officers are more likely to whatever, right? And if a venereal person answers, yes, I'm predisposed to believe police officers, wouldn't we at a minimum expect the judge to probe that answer to determine whether the juror is impartial or indifferent?
Well, usually the question is asked because of their employment as a police officer. I mean, people
Sure,
are people.
but it could be for whatever reason. Are you more likely to believe a police officer? Are you more likely to, whatever? It seems to me that the questions go to the same core question, which is, do you have some kind of presupposition about whether a certain type of person, could be rape victim, could be police officer, is likely to be telling the truth?
Well, I think a big difference here is there's no empirical evidence that police officers are more truthful than the population at large.
But there was no empirical evidence at the time. I mean, no one put this empirical evidence before the judge or anything. I mean,
Right, but I think it's common knowledge that it is very infrequent for false accusation rape, especially.
Well, you're saying that that's actually it's in the King case, is what you're saying, right?
It is in the King case. SJC cited with approval, Department of Justice statistics. I threw in a couple more very well-respected studies.
Can we move to the other statement though? Because the other statement, you know, we've got case law that says that prosecutors aren't allowed to say that, right? Not allowed to say, hey, look, because the person, you know, why would she be in here if she wasn't telling the truth? And you've got, so you got a question, you know, are you predisposed? Do you have a view that someone who comes into court is more likely to be telling the truth? What about that one?
Well, this was a question from defense counsel, to be fair.
Well, you opened the door, the prosecution opened the door to this whole line, so, but continue.
Right, well, defense counsel followed up with that, which I think is a natural outgrowth of the previous question that he had asked the panel. I don't, again, because it is an outgrowth, I think the 2% has application there as well. It's not anything that either side can argue, and that's the point here. The judge tells the juror, instructs the jury that they're to consider this case on its merits. Here, the jury had a overview of what the case was about, a pretty good factual overview provided by the judge. They knew what kind of case this was. The judge screened the jurors to make sure they were fair and impartial in this case. And this was before the jurors received the comprehensive instructions, both before, during, and at the final instructions from the judge on how to evaluate evidence. And so, and that's a point that Chief Justice Kapker made in the Nelson case, which was one of those, do you believe officers more than civilians? He said, well, all this took place before the comprehensive instructions from the judge. And in that case, this court said, better practice would have been to ask a follow-up question. But we're dealing with the abuse of discretion standard. The judge on the ground is entitled to a wealth of discretion. As was mentioned earlier, perhaps there's no other aspect of a criminal trial that is accorded more discretion. Chief Justice Gantz's concurrence in the Williams case called it substantial discretion. And there's terms throughout the case law. The judge sees the jurors, sees counsel, can evaluate the jurors, not only what they say, but how they say it. And in this case,
if we were to disagree and conclude that,
you pause for a minute? I assume that Judge Ellender is still there.
I think he went to go get a book as my guess.
Okay, just
There you go. Book in hand. If we were to disagree and conclude that the judge should have inquired further here, which is what I understand now to be the argument of error, that the judge should have inquired further in order to determine whether the jurors should have been excused for cause. What is the standard by which we assess that error? In other words, here the objection was preserved. It's not an unpreserved issue. What are we reviewing for?
Well, because the defendant exhausted the peremptories, I believe I can't.
It's structural. It's structural.
I would call it there's no way to. There's no requirement the defendant establish prejudice. If there's a biased juror sitting on the jury, that's it. That's what
I thought too.
So, counsel, did the judge ever instruct the jury that it's not supposed to believe that just because someone comes forward and puts themselves through the ordeal of a trial that they are telling the truth? Because as somebody else already pointed out, we don't allow prosecutors to say this.
No, the judge didn't specifically rebut the sentiment, the question at the time. What happened was this was pretty much the last of the panel voir dire questioning. The attorneys went to confer with their notes to determine who to challenge for cause. The judge went on for 5 pages giving preliminary instructions to these jurors. The prosecutor exercised peremptory challenges. Only then did defense counsel raise an issue about these jurors should be challenged for cause, which we're talking 13 jurors on this panel, or have further voir dire. The judge said, I don't believe those opinions are the kind of things that would warrant either.
So, I'm sorry, I missed that, and I want to make sure I understand. The judge had pre-charged the jury before this objection was raised?
He gave preliminary charge to permit.
Did he give it? Was some of that preliminary charge about instructing the jurors about how to consider impartially the testimony of witnesses?
Yes, well, in part, and this is page 107 of volume 2, and one of the instructions is, during the course of the entire trial, you must simply keep an open mind, not form any judgment as to any aspect of the case. Of course, as you know, evidence in a trial comes in little by little, witness by witness, exhibit by exhibit. And so you have to keep an open mind until all the jurors deliberate at the end of the case. And there were further instructions. As I said, there's probably 5 or 6. And then toward the end, he also said, it's up to 15 of us to ensure a fair, he's including himself as a juror, a fair, just, and equitable trial for all the parties in this case. So he was giving substantive instructions.
Is Nelson your best case?
Well, I like Mahoney because that dealt with the pre-instruction issue where a judge screened jurors for bias and then declined a request to follow up. I liked Nelson also because it recognizes the discretion that is accorded to trial judges. And even though reasonable judges can disagree, under the reformulated abuse of discretion standard, LL versus Commonwealth, it must be outside the range of reasonable alternatives to find an abuse of discretion. And here, as I mentioned before, it's almost extra discretion. It's substantial discretion, to use Chief Justice Ganson's words, because the judge is seeing the jury, hearing the jury, and the judge individually questioned each of these jurors and asked each of these jurors, is there anything about the nature of the charges against the defendant that would make you unable to sit as a fair and impartial juror? And each of these jurors answered no. The judge was entitled to rely upon that. And that's the word used in the case law, entitled. They affirmed their impartiality. And the judge was entitled, as the judge conducting the jury selections, he was entitled to rely on it.
Have we used that statement of the law in cases where the jurors have given potentially conflicting answers? I mean, here they say, yes, we can do it. And then when probed about a particular aspect of how they would assess the evidence, they give an answer that might be at odds with their global answer. So have we said the same statement that you just read to us in a case where that's the state of play?
I don't have a case off the top of my head. It's the, let me see which case used the word entitled, is the Supreme Judicial Court in the Mahoney case, which is a case I like because that dealt with the pre-screening of jurors for bias, a request later by defense counsel to ask a follow-up question, and the trial judge declining to ask that question. And
Okay, I just read the instructions you directed us to, and I didn't see any explicit statement about bias or how to assess the credibility of witnesses.
Oh, from the judge himself?
Yeah,
I
the
was quoting directly
instructions.
from the transcript. So volume 2, page 107, the first full paragraph.
Yeah, I looked at that.
That's the one I quoted.
Yeah,
And then on page 109, the last paragraph, the judge talks about it and up to all of us, including the judge, to ensure a fair, just, and equitable trial for all the parties in this case.
right. But it does, neither of those goes directly to how to assess the credibility of witnesses.
So that would be, that's when I referred to that before, that was in the final instructions. That's standard instructions on how to address the credibility of witnesses. And so in the Nelson case, this court made the point that the challenged juror there had not even had any instructions on how to evaluate the evidence or judge or evaluate witnesses. And that was one reason for deferring to the trial judge in that case. And this court in Nelson, Chief Justice Cather said, reasonable judges could disagree. The other prosecutor would have asked a follow-up question, not so much because I don't think because it was obviously a bias issue here, but I would do the same thing just to clean up the record. But it doesn't mean that that's the standard. It's the judge, whether that was an abuse of discretion. And I submit that it was not an abuse of discretion, especially considering the screening he had done individually of each of these jurors and the judge's perception, hearing the answers, seeing the jurors, and determining that further individual voir dire of 13 jurors again was unnecessary in this case. Unless there's further inquiry from the panel, I'm willing to rest my brief.
Let me see.
I guess I'm just trying to understand if you think the defense counsel introduced error here by asking that question or being permitted to ask that question, or in failing to then subsequently ask for a jury instruction to counter the question that he asked, so that the jury was expressly told you can't decide she's credible just because she came here and testified.
Oh, I don't think the defense counsel did anything inappropriate. I think the prosecutor introduced the topic, and this was a 2-day selection. The prosecutor asked a similar question the first day, and on the second day introduced the topic. The defense counsel, which I think was a natural outgrowth of that question, asked a follow-up question about going through the process. I don't think there's a difference between the questions, and I think it was an appropriate question to ask. I just don't think it's like as in the Clark situation, having to do with racial stereotyping. Here, there's empirical evidence to support, and it's almost common sense that it's rare or infrequent for rape accusations to be false.
All right, let me see if there are any further questions. Nope.
We are live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this fashion due to the ongoing pandemic, but according to all the ordinary rules of argument in our court, which include that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of 2021 P0592, Commonwealth versus Patrick AMARA. And Attorney Von Flatern, we're ready whenever you are.
Thank you, Your Honor. Good morning, Your Honors. Cynthia Von Flatern, Assistant District Attorney, Northwestern District for the Commonwealth. This is the Commonwealth's appeal of the trial judges and the motion judges' allowance of defendant's motion for new trial. The defendant was convicted of 3 counts of rape, 2 vaginal and 1 anal rape, and for the motion for new trial, it was a one-issue motion arguing ineffective assistance of trial counsel. And that was based on the affidavit of trial counsel that stated that he had prepared or sent off the file to appellate counsel and the defendant, and with inquiry from the appellate counsel stated that he had not reviewed a UMass summary, a summary by an assistant dean who interviewed one of the witnesses in the case. By the time we had the motion for a new trial, the trial counsel actually stated that report and another report regarding this witness were actually in his trial file, and he concluded that while he didn't have a present memory of those reports, that he must have reviewed them prior to trial. And at the hearing, he stated on the record that he didn't have a present memory, but seeing them now, he felt that they would have been something that he would have reviewed with his client, with the defendant, and possibly used. But there was no further details provided by defense counsel, by trial counsel, as to how those would be used. Certainly argument on the part of the defendant, and the judge agreed with the defendant, finding that there was ineffective assistance. So the Commonwealth would argue.
Counsel, the judge made a finding about whether or not the attorney had reviewed at least one of those statements. Are you arguing then that that was clearly erroneous, or really more specifically that the trial judge really could not have found that counsel had failed to read one of the statements?
The testimony at trial, Your Honor, and I think we're based on, not on the affidavit, which was different than what counsel testified to, because
Motion hearing, right?
yes, at the evidentiary hearing, at the motion hearing, he indicated he didn't have a memory of it, but he acknowledged that he would have read those reports.
So is your argument that it was that the judge's so the judge made a finding that he had not read it? Are you arguing that, I believe he made that finding, are you arguing that's clearly erroneous?
Yes, to the extent that he makes that argument, we're arguing that he had reviewed it, and I think the judge then goes to prong two.
But how can we find it's clear error, right? I mean, one of the key aspects of that, it seems to me, is, was there any indication at trial that he tried to use those statements? And the judge was at trial and has a much better perspective on how things played out than we do.
Your Honor, there was no indication that he tried to use the statements. We're talking now about two statements, although the defendant identified only one in the motion. There was a second statement to the Hadley Police Department, and in that statement, Mr. Odom, the witness, says, and he's talking about the first complaint witness, who was his girlfriend, "I remember Maya telling me she was worried about H, the victim. She had been drinking, and Pat, the defendant, had been drinking as well. I remember Maya saying that H kept saying no, and Pat didn't stop."
But that doesn't help you. I mean, that hurts you. Now, there are two documents in the lawyer's file that the lawyer attests he did not see, then says, well, they're in my file, I must have read them. And the judge basically says, apparently overlooked, because no indication that he tried to use those at trial in any way.
And then we must go to why would he try to use them? With respect to this statement to the Hadley PD, he said the first complaint witness told him the victim kept saying no. So that there is part of the elements of rape. So it's just repeating the rape allegation. It's repeating the first complaint.
No, it's not. No, to the extent that one can read those documents as suggesting that the sexual encounter began consensually, it's useful to the defense because it undermines the testimony of the victim.
I believe that the statement to Hadley Police Department doesn't make out a consensual encounter at all. The statement to UMass, which is a summary of what Mr. Odom said to UMass, that says H and the defendant were having sex, and she said no. So that would make out that it started consensually, and then states that there is a rape. But yes, there is a difference in what H testified to, what the victim testified to, and what the first complaint witness testified to. With respect to the drinking, the Commonwealth's position is that that was really a non-issue, and it would be understandable not to pursue that at all.
But counsel, let me pause you on that for a moment, because the defendant characterizes the Commonwealth's case as one of a sober victim unable to fend off an intoxicated rapist. Is that a fair characterization of the Commonwealth's theme there?
Well, certainly all the evidence stated that the defendant was highly intoxicated. And this case
But
was
the
not
issue
just
is what the victim's sobriety was, wasn't it?
that the testimony, the evidence was that she was sober, but it wasn't a situation where the government tried to make her out to be to sugarcoat her in any way. She testified
No,
that
but
she
I
drank
think
heavily
that-
after.
Yes, but I think that, just so we're really joining the issue here, I think the defendant is saying that the Commonwealth was presenting her as a sober witness, and that the statements, if believed, would call that into question and call her credibility into question.
Well, whether she had been drinking or not, I don't think that helps that helps the defendant on the consent issue at all. In fact, it could show this young woman is more helpless, and the testimony is he's a football player. So I don't think it helps the defendant in that respect at all. And the Commonwealth just presented all of the evidence said that she was sober, because we had the defendant gave an audio statement to UMass. It was an investigation. He had been drinking heavily. He never indicated that she was drinking with him or drinking at all. They were sitting on the couch before they went into the bathroom. Both of his witnesses testified. They didn't say anything about her drinking, and Mr. Bowe, who was a very close friend of the defendant's, testified he was concerned about the defendant. He was the one that was drunk. And actually, in Mr. Odom's this summary of the statement, it says they were both drinking and H was drunk. Well, that seems to be totally backwards, because everyone would agree that the defendant was drinking heavily. And whether the victim was or not, I don't think it's a critical issue. But the fact at all, the evidence simply pointed to the fact that she wasn't drinking before the rape.
How can it not be an issue that is worthy of significance? Significance in a case where she's the victim and she says, this is what happened. And the case depends on her testimony that she may have been intoxicated at the time.
Well, and it also,
it's gotta be relevant to any juror, because the case is about her credibility, what she recalls.
I would submit, Your Honor, that we're talking about, we don't have a situation where a percipient witness said that she was intoxicated. And that would be different. We don't have the first complaint.
Odom himself testifies that she did not appear to be intoxicated, right?
He was pretty silent on that. He wasn't there at the time of the rape. He came in just after. And he wasn't asked about it, but there was no testimony that she was intoxicated, and defense witnesses and
maybe I have this wrong. I
that.
thought that he testified that his observations of her were that she did not appear, maybe it was that she just appeared normal.
Yes.
Not that she did not appear intoxicated.
Yes, that would be correct, Your Honor. And the same with the defense witnesses, they would say. And in fact, even after the rape, the defense witness said she looked the same. She just had messy hair. Didn't indicate anything about her intoxication whatsoever. And the defense witnesses
take these arguments to go to second prong of Safarian.
Yes.
Okay.
Yes.
So can we turn to the first prong of Safarian for a moment?
Yes.
Is the Commonwealth's position that the defendant failed to establish that his trial counsel's performance fell below the standard required?
Yes, Your Honor. It's the
Okay, and is
Commonwealth-
that because you think he read the documents and that's all that was required? Or is it because he didn't read? What are you saying that the attorney did fine? Are you saying the attorney read the documents and decided as a strategic matter not to discuss them with his client or use them at trial?
I think that can be inferred from.
I'm not worried
From-
about inferences. I'm trying to figure out what your theory is
Mhm.
for the obligation of counsel in this case, when they have these documents.
Well, I think the Commonwealth, that we have two arguments. The first is that he read them and determined that they weren't that they weren't material, and he would not use them.
Okay,
But
so
that it was
that there's no evidence of that, direct evidence. The only evidence that we have from the evidentiary hearing is that he would have seen them and that he should have discussed them with his client at a minimum, and then decided what to do with them at trial. There's nothing to permit a judge on this record to infer, is there, that he made a strategic decision not to do that?
Well, I
What
think
would the evidence be to support such a finding?
well, the defense counsel testifies, as I explained to you, it is in my trial notebook, so I certainly saw it prior to the trial.
Right,
And
so
that-
he saw it. And then
If I could, I thought there was another argument, seems to play through your briefs, that it can be inferred that, or maybe not put it, let me put it differently. It's not at all clear how he could use this document because it's hearsay.
Exactly, Your Honor. That's the critical point in this case, and the Commonwealth submits that
And
there was.
so there's no falling below standards if the document was unusable.
Exactly. And the Commonwealth submits that the error here in the decision on the motion for new trial is that it's a very high standard. The defendant has the burden. There was no evidence as to what Mr. Odom would have said, or what the first complaint witness would have said, or what the victim would have said if cross-examined or confronted with this.
Right, but which way does that cut? Shouldn't the question have been asked? What's the harm in asking the question? Didn't you tell your boyfriend that Hall was drunk? I'm sorry, that H was drunk.
Well, with respect to the question about the drinking, I don't know that there is that much harm in it, but you also have to weigh what we're talking about is overturning a jury verdict. There's a presumption of finality and interest in the Commonwealth, not just the prosecutor,
And
but
I
the Commonwealth
understand
has
that
an interest in
argument, but
finality.
actually what we're talking about is overturning the decision of the trial judge to grant a new trial, which is a very high bar, isn't it?
Well,
Abuse
I
of
think
discretion.
that this court can look at whether there was error or not, and in this case, I think
And
that
the
Right, but
error
if
is-
we're looking at the impact on the trial, don't we have we have many cases where we say that we give special deference to the trial judge in that regard, who's also, when he's also, he or she is also the judge acting on the motion for new trial, in assessing the impact on the trial.
I think that the standard is also whether there is error, and this isn't a case where the judge even considered how, was looking at closing arguments and how that would have played for the jury. What happened here was there is speculation as to how that could have been used in this case, and it was very weak evidence to begin with. It was third-party hearsay, and that would have made a difference in
But
this case, I
counsel,
think.
You write in your brief at page 29 that it's true that trial counsel could have used Odom's out-of-court statement to try to impeach H. So could you give us an example of that so that we're all on the same page?
Well, and it would have to start with that there would have to be a showing that Odom adopted this statement, because the summary could be false, could not be correct, might not be correct. It wasn't his statement. It was only a summary of that an assistant dean wrote at the university. So if he adopted that statement, they could have asked the first complaint witness, did you tell your boyfriend that H was intoxicated? But I mean, I think that she would say no, and that would just make her testimony stronger. If she said yes, well,
That would
I
help
guess
the
that goes
defense.
to whether
She said
there was
yes,
no
that
reason
would
for
help
her
the
to.
defense.
I'm
Right.
sorry,
If she said yes, that would help the defense.
but we don't know that she would say yes, and there was no
Correct.
testimony at the hearing. The other thing is, with respect to the second issue on
I'm gonna have to, your time is expired. I'm gonna have to leave it here. We're gonna have to leave it here. Let me see if there are further questions from the panel. No. All right. Thank you very much. Attorney
Thank you, Your Honor.
O'Brien.
Thank you. Good morning, Your Honors. So I think starting off with this issue of the trial attorney and the statements, I think that what I would say is, regardless, there is no evidence to my eye that he actually read the statements. What I believe he said.
Okay. I think I'd like to start there. So and to me, it will be helpful if you're looking at the same page of the judge's decision. So I'm looking at page 8 of the judge's decision, next to the last paragraph underneath the heading where it says evidentiary hearing. And in the second sentence of that paragraph, the judge says, based upon a preponderance of the credible evidence adduced at hearing and Attorney Drake's affidavit, I find as follows. Now, the only evidence adduced at the evidentiary hearing was Attorney Drake's testimony. So basically what he's saying is, this is what I find based on Attorney Drake's affidavit and testimony. And then we look on page 9. And he says, the judge finds that Attorney Drake acknowledged that after Drake signed the affidavit, he located copies of Mr. Odom's UMass statement and Mr. Odom's statement at the Hadley Police Department in his trial preparation file. Although he does not have a specific recollection of reading either statement, he believes he must have done so because they were in his trial notebook in a section relating to Mr. Odom. So I think we have to accept the judge's finding that Attorney Drake was aware of those statements before trial.
Right. And
Okay. And then the only evidence of what the standard of care might have been that you presented was Attorney Drake's statement that he would have at a minimum discussed them with his client and then decided what to do. Is that what you are contending is the ineffective assistance of counsel, the failure to discuss them with the client?
I'm contending that the failure to discuss them with the client and the failure to use them at trial are both. So regardless, either
Okay,
way.
so there's no affidavit from your client saying that there was no discussion with him about the documents?
I believe there is, Your Honor. I believe
I didn't see that. Where is it in the record? If so, I apologize.
No,
I
maybe
went looking specifically for one.
there is, Your Honor.
Okay.
It should be part of the record. It's short. It's 3 paragraphs. Defendant's affidavit in support of the motion for new trial.
All right, I will go looking for it again. I didn't see it, but all right. And then with respect to the documents use at trial, you don't really go through this in your brief. Can we agree that they are not admissible because they are hearsay?
On standing alone, yes.
Okay, so they could be used for, you tell me,
So I
which
think,
witnesses and how could they be used?
so they would be used in cross-examination, at least of the first complaint witness, who is the girlfriend.
How is it going to be used to cross-examine Hall?
So, Justice Englander, I think you touched on this a little bit earlier. So she could be asked, because with Odom's statement, the defense attorney has a good faith basis to say, didn't you tell Odom, didn't you tell your boyfriend that H and Patrick were having sex, and that she, said to stop and he didn't? It absolutely could be used to cross-examine her. Obviously,
How would that help you?
if she says I did, then
Yes,
obviously
how
that's
would that
helpful.
help you? It basically constitutes a report of rape.
Well, Judge, here, so the overarching problem in this case, I think, for the defendant, and the reason these statements are so critical, is because the Commonwealth presented this case as, and Attorney Drake actually admitted this at the motions hearing, as the defendant being the aggressor and attacking H in the bathroom, literally pouncing on her. There is no other evidence in the case, absent the defendant's own statement, that supports the idea that that was not the full picture of what happened, that this very well may have begun as a consensual, to use the vernacular, hookup, and then perhaps H.
And then
wanted to-
became rape?
And
I
then
mean-
H, I'm not saying that that might not make out the elements of rape, but what I'm saying, Judge, is that given the evidence, given the entire universe of evidence that the defense attorney had at the time, there was nobody else, there was no other evidence to back up the defendant's version of what happened, except for these statements. This is the only evidence that he
issue
had.
is that it doesn't matter which of those statements the jury believes, both would be rape.
We don't know, Judge, because then we have an issue of withdrawn consent. The jury wasn't obviously instructed on
It's inconsistent
withdrawal
with
of
what the
consent.
victim testified to. It's
I'm sorry,
inconsistent
Judge.
with it's inconsistent with the victim's testimony. It contradicts the victim's testimony. And
Correct, and it
therefore
also-
it calls into question all of the victim's testimony, it seems to me, at
Yes.
least as normal thought about impeachment. The
Yes.
difficulty
Right, so-
for your case, counsel, and I'm sorry, Judge Wolohojian, I'm really following up on the question you asked, is how could it be used, and you say, to be used to ask the following question, which apparently was not asked, right? Didn't you tell Odom that H was drunk? Or didn't you tell Odom the following? But it seems pretty darn collateral in its totality. You don't know what she's going to say. She's already testified to her own observations of H. So she's going to be rehabilitated on redirect. Did you observe her? No, I didn't observe her to be drunk. No. So, the difficulty I have is with the notion that this is sufficient to overturn a jury verdict.
Well, Your Honor, it not only could have been used to cross-examine the first complaint witness, it could have been used in the same way to cross-examine Odom and the victim herself. Didn't
Can I
you
just
tell?
ask, do you agree
How?
that the document itself would never have been able to be admitted, even if the witnesses denied? So if Hall says, no, I never told him that, the document's not going to be able to be admitted. Same thing with Hall, same thing with H. I'm sorry, same thing with Odom, same thing with H. Document's not coming in, right?
Correct.
Okay, so it's just the document is like what you're saying is the fact that this existed in the file gives him good faith basis to ask some questions that were never asked. And those questions could have been significant for the defense.
Yes.
Well, let's just-
If the witness adopted them.
Yes, but Judge, the problem is, that we can't speculate. The Commonwealth
Right,
speculates a
so
lot.
I
We
mean,
can't
and who has the
speculate.
burden on the motion?
Well, but this is why the statements were so critical in this particular case. It's not a situation in which these statements are collateral to another witness who said this is, it was consensual, or another. This was it in this case for this defendant.
But I take it you're saying that if the defense counsel had asked either H or Hall, didn't you say X to Odom, or didn't H say X to Hall, or didn't Hall say X to Odom, and they either agreed they did, in which case that would be significant for the defendant, or they disagree, and then when Odom testifies, he's impeached with, he either adopts his statement, in which case now we have a contradiction between the three Commonwealth witnesses, or he rejects it and then he's impeached and you have this contradiction. Is that, I'm just trying to understand.
Yes.
And at that point, is the Commonwealth entitled to put in the entire statement? Because the entire statement does not help you, or it might help you in part, but the rest of it essentially can be used to confirm that a rape occurred. So wouldn't that need to be taken into account?
I guess
The judge doesn't appear to have taken into account that these documents are both helpful and not helpful for the defense, potentially helpful and potentially not helpful.
but nothing else in this case was helpful for the defense judge, and that's.
But that also doesn't help you, because in assessing whether or not this deprived you of a substantial ground of a defense, it doesn't look like there was a substantial ground of defense.
Well, the defense attorney, Attorney Drake, opened his case and closed it by saying that his theory of the case was that this was a consensual encounter, and then later on regret. That was his theory of the case. And
so he was
statements that
able to
back that
present
up.
that. He was able to present that theory, and this is the same theory. So I take it you're not saying he was deprived of a defense. It's just that he was deprived of some information that would have helped him with that defense.
The only information, to my mind, because, and I'm not saying these sexual assault cases are difficult for that reason, because there often are not, by their nature, precipient witnesses to the actual alleged assault. So to see these statements and to have to see them as the only statements in the case that single-handedly back up what the defendant is saying, what the defendant
didn't say anything at trial, correct?
His statement was played. His statement was played to the jury. He himself did not testify, but his statement was played to the jury. Yes. So I think to leave these statements out, given the totality of the evidence that the defense attorney had to work with, these statements were critical.
You said something in your brief about the defendant's trial witnesses being completely unhelpful.
I did.
Do you recall that?
I do.
In that kind of a situation,
these are witnesses that the trial attorney called. My reading of their testimony was that they came across as self-serving. They were fellow football players who were also at the party, and I didn't think they lent much to the defense.
Well, now, if they were believed, they surely did. They were evidence of consensuality, right? In particular, the testimony about the one who knocked on the door and said that there was a pink arm that closed it on him. So, when you say this was the critical evidence, Judge Wolohojian is pointing out, I think aptly, that no, there were three witnesses who also went to this same issue of whether it was consensual.
They contradict themselves, Judge. I'm saying taken in the totality of the case itself, their testimony in concert with each other was not helpful. Not
what you
because
said
it
was-
hurt, but because it came across as they were attempting to help their buddy.
So what you said in your brief was that their testimony alone and in concert lacked credibility and was largely ineffective. And
That's my belief.
that's your view of that.
But you
Yes.
weren't trial counsel, right?
I was not. I'm a trial attorney, but
You're
I was
doing-
not trial counsel.
Doing it off a cold record.
That's what I have. Yeah, that's right.
Let me see if there are any further questions.
Interesting case.
Is there anything further you'd like to add? Otherwise, we've got your briefs, we've got your arguments, and I think we understand the issues. It's an interesting case. We've been helped by both of your arguments very much.
We are live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. However, all the ordinary rules of argument in our court apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'll call the case of 2021 P0535, 57 Old Road to 9 Acre Corner LLC versus Richard Frasca. And Attorney Lofton, we are ready whenever you are.
Good morning, and may it please the court, Ned Lofton for the defendant appellant, Dr. Richard Frasca, as a personal representative of the estate of his deceased mother, Mary Frasca. We're appealing two things. First, the November 20th, 2020 decision and order of Judge Cowan in the Superior Court allowing the plaintiff's motion to enforce settlement. And secondly, the April 1st, 2021 decision of Justice Hagan in the Superior Court entering judgment under Rule 58A. Let me address first the argument that there was no settlement agreement reached.
So counsel, before you get too far down that road, I understand you agree, you are arguing that no agreement was reached, but do you agree that if an agreement was reached by January 4th and Mrs. Frasca died on the 7th, that it would be binding on her estate?
Well, I would say, yes, I would agree to that.
So
Continue.
what material terms were not agreed upon as of January 4th when you sent your responsive email?
Sent my what?
You sent a responsive email on January 4th, right?
Yes, yes. What was not agreed?
What material terms weren't agreed upon?
There are two material terms. Number one, the amount of money that Dr. Frasca as conservator would have to pay. And the second material term,
$300 a day from,
Yeah.
I forget, November of 2016 through the end of 2017, and $300 a day for the next year if Mass Health didn't step up. That
That's
was
right.
agreed on, right?
the second term was that the Care One wanted security for 2018. They proposed that
But that
money.
was agreed on, wasn't it?
No, it
Isn't
wasn't agreed
Cowan
upon.
right about that? Well, they said to you that if a bond company is willing to provide a bond for 1/1/2018 to the date of disclosure, that option may be used. And then you responded, I think we can safely secure all that period with a bond. Why
Well,
isn't that an agreement?
you left out the part where they said that the security by a bond terms would have to be satisfactory to them.
But what isn't that pretty standard language in a I mean, that's why is that not, why do you not have an agreement
Because
that they've got to agree to commercially reasonable terms?
they have to agree to commercially reasonable.
In other
terms.
words, you've agreed on a bond. They say
No, we haven't.
subject to our agreement as to the terms, but isn't there implied in that they can't be commercially unreasonable in demanding their terms?
No, I don't think so at all. They're saying if this bond's not satisfactory to us, then we don't have an agreement.
What are our cases say are the essential terms of an agreement?
Well, an offer and acceptance, a legal subject matter, that the material terms have been agreed upon.
No,
And
it's
that
not for evidence, but the essential terms of an agreement. It's usually just price.
For a settlement, yes. Usually it's
Just
just
price.
we pay X dollars, you dismiss your
Right.
case.
So when we're talking about this agreement, there may have been components that were not completely nailed down, but they may not be essential in order to find an enforceable settlement agreement. Because
Well-
unless I'm missing something in your argument, as Justice Englander asked you earlier, the essential component of amount had been agreed upon.
Yes, but the condition precedent imposed by CARE 1 had not been met.
Which condition precedent are you referring to?
That they wanted security for monies that would be due in 2018 in the event that
Mass
in the
Health
event-
didn't pay.
the Mass Health, and they wanted it now. They didn't, it wasn't, well, we'll wait till see what Mass Health does and then we'll want security. No, they wanted the security now. They wanted it put into an escrow. And it was us that proposed a bond. And they said, all right, we'll consider a bond, but we need to approve the terms and the amount of security. Nothing could be a more clear condition.
Okay, so that
for
hadn't been
than that.
finalized. Well, the condition had been agreed upon. Just the details of the condition had not been agreed upon, which
Well, the
is what
condition-
does that bond look like? But all
The
right,
condition had not been accepted by CARE 1.
Oh,
They're
But
not
Care-
accepted.
yeah, well, CARE 1 though says perhaps a different way to follow up on Judge Englander's question, that there are objective standards by which to enforce the agreement for security. That, you know, that it was objective, that the terms covered the terms of the bond met the needs that the parties had articulated and agreed upon.
Well, you're saying that I could have asked the court later on after a bond was issued to require CARE 1 to accept the bond. That's what you're
Absolutely,
saying.
because this has got to be a mutuality. In other words, if this agreement is an agreement, has to be something that a court would enforce on either of your sides.
Yes, and you know, I'm relying on the case cited by CARE 1, Basis Tech Corp versus Amazon.com, Mass Appeals Court 71, page 39, where this court says that one of the elements is the parties had the intention to be bound by their agreement at the moment of its formation. And it cannot fairly be said in this case that there was intention to be
is that a
bound by
question
both
of
parties
fact?
at the moment.
Is the
It is
party's
a que-
intent, is the party's intent a question of fact?
It is a question of fact, but
So under what standard do we determine, because clearly the motion judge here made some kind of factual determination that the parties intended to be bound. What is our standard of review for that kind of fact-based finding?
well, as I pointed out in my reply brief, since this is all done on paper from the emails and so forth, this court's perfectly able to reach its own decisions based on the same paper the trial court was looking at. So that's the standard. You review this case as though
Did
you were
anyone
Nisi.
suggest to the trial judge? So there's a motion to enforce the settlement filed by your opponent. Anybody suggest to the trial judge that she needed to take evidence on this?
No,
So both of you basically were prepared and comfortable with having the issue presented to the judge on the paper record
yes, I
With
think
our-
that's a reasonable inference.
with argument.
Yeah, the wrinkle here on the point of being bound by an intention to be bound at the moment of the formation is that the trial judge said, well, 2018, since Mass Health did pick up the cost of 2018, the question of a bond or an escrow is mooted. That was an improper analysis by her, since to find a contract that's binding on the defendant, you have to find there's a present intention to be bound at the moment of its formation. And it's clear that Care 1 was not intending to be bound unless and until there was security that was satisfactory to them, which brings us to the point that Ms. FRASCA died 4 days later, leaving Dr. FRASCA as conservator with zero authority to proceed with respect to a bond or an escrow or anything else. So there's an impossibility there in terms of him completing the terms of the proposed contract by Care 1. Which,
Well, it's not an impossibility. I mean, if there's an agreement that is made on her behalf, that becomes an obligation of her estate, which fortuitously, your client also becomes her executor. So I don't understand this part of the argument. You're going to have to, you need to play out for me. It seemed to me that part of your argument fell out of the case, because what the case turns on is whether there was an agreement at a time when he had the authority to make the agreement.
yes, and I've already argued that there was not a completed agreement at the time he had the authority to make the agreement. And there would have been, except Care 1 interrupted that with their insistence on a security that was acceptable to them.
So,
And after she died, Dr. FRASCA was unable to even pursue that.
he
So there
was
was no-
unable to pursue that. Okay, well,
Pursue their condition that they wanted security acceptable to them. She died 4 days later.
Right, he could have pursued it, he chose not to.
No, he has no authority to pursue it.
Well, he has no
There's-
authority as conservator, but he had authority ultimately as executor of her estate.
Ultimately,
Yeah.
but the law is whether there was an agreement at the moment of its formation.
So that part of your argument I understand, but you argue there's a statute of frauds issue here, and that I don't fully understand, or at least I guess I'd like to hear your response to Care 1 argument that the emails themselves take you outside the statute of frauds because they are writings.
Well, they're not a writing signed by Dr. FRASCA, which the statute defining the statute of frauds requires.
is there any case that says that an email with your name on it isn't enough?
Well, his name's not on it. My name's on
Sorry?
it. His name is not on the email. My name is on the email.
But you were acting as his agent for these purposes, no?
Yes, I was, but the statute requires that his name be on the document.
Is there any case that says a signature by your lawyer is not sufficient? Because I'd be surprised at that one.
Well, I would be surprised if there was one that says the signature by the
Well,
lawyer.
rather
is
rather
sufficient.
than worrying about who's surprised, did you have a case to support your
No.
argument? No.
I mean, I have a case to say that the executor is not bound by the agreements of the conservator.
But you don't have a case that says the signature of the attorney acting within his authority from his client is not enough to satisfy the statute of frauds.
I do not know. Let me address briefly the amount of the judgment, which is the second part of this appeal. Dr. FRASCA is under the impression that he was going to get credit for the $35,000 he had paid, whether he paid just for 2017 or 2017, 2018, that he had paid $35,000 that was going to be credited. It didn't come up that that wasn't true until they filed a motion for the entry of judgment under Rule 58. And it was only at that time that Care One engaged in this argument that, oh, part of that money was for 2018, the other part was for 2017. So
Right,
he
so
only gets.
counsel, I understand you're arguing about the meaning of the language, but you're not arguing that you're not disputing the $27,200 and so dollars were paid for this 2018. He's just saying there was no time limit. Any money I paid should have been credited, right?
Yes, absolutely. I mean, that settlement is just, I'll pay money and you dismiss the case. And he was saying, I'll pay money, but I want credit for what I've already paid without limitation of time. And nowhere was that ever discussed to break it down for 2018 until this motion for the entry of judgment came up. In fact, the trial court's decision enforcing the settlement said simply, quote, FRASCA estate is paid $300 per day for the period from November 2016 to 2017, minus amounts already paid by FRASCA or third party.
Right, so as a matter of grammar though, why doesn't that date restriction also apply to the time period where he made payments?
Because 2018 had been resolved by the Mass Health approving the request to have them pay. And
But
the
we
fact
don't know that on January 4th, right? The language.
no,
they
we
agreed-
don't. And we don't know, well, we don't know it at the time the judge is entering her, Judge Cowan in November 20, we know it then.
Right,
And
but
the
your reading of this language requires us to add some words that, so instead of just minus amounts already paid by FRASCA or third parties, we're really saying at any time, not just this time period stated.
No, all you're required to say is that he gets credit for the amount that he paid as of January 4th. Okay, and the fact that there's a dispute about that where we're saying we get full credit and they're saying, no, you only get credit for what you paid in 2018. That dispute by itself demonstrates that there was no meeting of the minds on January 4th.
Okay.
Well, I'm going to go ahead, Judge Wolohojian.
No, go right ahead, Judge Henry.
Well, I'm going to predict that your colleague on the other side is going to say that it's your client just being difficult and that he's trying to muddy up what is perfectly clear language. And
Well,
that you can't just create a dispute by saying, I make a dispute. Do you have a
Well-
case that says that he can just make a dispute?
There's nothing in this record that tries to break down the payments to 2017 or 2018 until the motion for entry of judgment is heard in April of 2021. Nothing.
Okay, I think we're going to have to leave it there unless there are
Yeah.
further questions from the panel.
Thank you, Your Honor.
Nope, I don't see any. Thank you very much. We have your argument. Attorney Fogarty?
Members of the panel, may it please the court. My name is Joseph Fogarty. I'm the attorney for the plaintiff in this case and the appellee. To begin, I want to address the standard for determining for the enforcement of a settlement agreement. As your honors know, the standard is to apply principles of general contract law. The fundamental issue is whether there is an intention to be bound. as to the material terms. And there are, Massachusetts law is clear that there does not have to be, not every term has to be agreed to with precision. And there can even be an agreement to negotiate further, or as long as there are objective criteria to enforce the agreement. And further, the deference of a final written memorandum is not, does not detract from the existence of a contract when there is an intention to be bound by the material terms.
So can I, counsel, I'm going to interrupt, and I'm going to say that whenever I did these things, if somebody wrote to me and used the following language basically as the topic sentence of their letter, I wouldn't think I had an agreement. We have reached an agreement about some terms remain unresolved.
Well,
that doesn't sound like an agreement. In fact, when I was practicing law, that was not an agreement. That was somebody saying to me, we've got work to do. So how do we get from there to where the judge got and where you want us to get?
Sure. So the determination that there is a present intention to be bound, it's a factual determination, and the trial judge can weigh a number of different factors in reaching that conclusion. The words used by the parties, the agreement as a whole, and the surrounding facts and circumstances. And I think in this situation, you have to look at the agreement as a whole, or in other words, the email as a whole. It's clear from reading the email, the full email, that the terms that remain unresolved was simply the form of security after 2018. Because 2019 had just started, and there was a question on how to secure future payments. You couldn't put them in an escrow because we didn't know what they would be at that time. But the actual terms that were unresolved was simply the form of security. There was an agreement that there would be security. And so the material terms had been agreed to. There was just this.
So, but his response back to you is, well, you wanted to make sure you were comfortable with the language of the bond. You were very distinctly and specifically insisting on this point, and we don't know whether you would have been comfortable about a bond that hadn't been secured and we didn't even have a template for.
Right. Well, the email that I sent on January 3rd contains language that sort of limits my discretion to reject a bond, or limits my client's discretion. It states that we reserve the right to review the terms of any bond arrangement to determine whether it satisfies our need to secure the debt. So right there, we don't have the ability to just reject the bond just because, for absolutely no reason without any qualification. If we were to do that and the bond did satisfy the need to secure the debt, then Mr. FRASCA could have brought a motion to enforce the settlement or sued my client. And if we had acted unreasonably, we would have been in the wrong. We didn't just have unlimited discretion to reject the bond.
So I have two questions that come out of, one comes right directly out of the letter and one comes out of what you just said. The question that comes out of the letter is the penultimate paragraph. It is important to my client that if FRASCA defaults, would be entitled, Care 1 at Concord would be entitled to pursue the full amount owed at the private pay rate, which he explicitly disagrees with. Now, nobody has briefed whether that is a reason that there's no agreement here. Why isn't it a reason that there's no agreement here?
Because that was not the trial judge, Judge Cowan, I believe in her decision, addressed that. And essentially she pointed out that is simply not something that the parties had agreed to orally. It was an assertion that I inserted into the email in which Ms. Lofton did reject. So if there was an oral agreement, then if I try to add an additional term, that would not alter the fact that there was an oral agreement. But further,
whoa, you completely lost me now. I thought our agreement was based on the emails, not an oral agreement. I don't recall Judge Cowan talking about an oral agreement, and I'm looking at her opinion, and I don't recall her talking about this particular clause. Now, maybe I just missed it. But she's not enforcing an oral agreement. She's enforcing the agreement that comes from the emails, right?
That's true. You're correct about that. And she does address it in her footnote 4.
Oh, okay, there, let me just read that. Thank you.
Sure.
Defendant, what I remember her writing and what I've underlined, the defendant does not raise this issue as a grounds not to enforce. It would be futile, as Care 1 never proposed preservation of the right as a term of settlement. I don't get that. Yes, they did. It's in their letter. You wrote it.
There's two reasons. There's two issues there. One, it wasn't something that was discussed orally. And I understand Judge Cowan's finding is not that there was an oral agreement. She's essentially focusing on the email exchange and saying by January 4th is an agreement in writing. And I believe that's correct. I think there was an oral agreement, and then there's also an agreement in writing to the extent that there wasn't an oral agreement. But that term is not a term of the settlement. It's merely stating that it's important, if FRASCA defaults on the settlement, then Care 1 would be entitled to full pursue the
But it's not correct as a matter of contract. It's wrong. As a matter of contract, all you would be entitled to is what you have under the contract. The only way it can be right is if it's written in as a new term.
Well, my understanding was that if there was a material breach, and I clarified this in a subsequent email, that essentially you could pursue the full amount owed, and that my client would not be bound by the contract. That was the meaning of that statement. It wasn't a term of the contract, and I think Judge Cowan correctly found that it was not.
Once again, I'll tell you, one of the things that we've got to do, counsel, is we have to fit this in within a framework of how lawyers operate every day when they talk to each other about settling a case. First 5 words of that sentence are, it is important to my client. Sorry, 6 words. I used to take that as a signal that if I was going to disagree, we didn't have an agreement. Why isn't that exactly what it's signaling?
Well, because we already had an agreement. We had reached an agreement orally that this email memorializes. However, let's say for the sake of argument, you conclude that we did not, there was no oral agreement, and you're to look solely at the emails. Well, the email exchange, Mr. Lofton responds the next day. He states that he disputes that, and then I respond to his email, and I don't raise any issue with that. So by that point, there was an agreement, just based on the emails.
Is there an email that comes after his email? I didn't see any record of that.
Yes, it's on page 62 of the same day I responded to him. On page 63 of the record appendix, and I asked, do you know if the bond can cover payment until whenever she is discharged, or does it have to have a specific end date? ? And then Mr. Lofton responded, paraphrasing, that he would check on that. So in responding,
so your contention is, let me make sure I understand, because I think I get it. You're saying, look, those are also part of an email chain prior to the death of his conservatee, that from which the judge could find an intent to be bound, and because you did not object to his objection, that's further evidence of meeting of the minds on that issue as well.
I think that's correct.
Okay.
And I also don't think it was a proposal of an additional term of settlement. I think it was just a discussion about, separate from the settlement agreement, concerning whether Care 1 would be bound by the agreement if there was a material breach on Mr. Frasca's part. Mr. Frasca thought it was a liquidated damages provision. That's not even really what was meant by it. But in any event, Mr. FRASCA did not raise this issue in the lower court as a reason why there was no settlement. It wasn't briefed in the lower court, and Judge
So
Cowan
he's
noted.
waived his ability to make that argument?
Yes.
Okay. The other thing you said is, you know, if he had sought, he meaning your opponent, had sought to enforce this agreement, he would have been able to. And again, I was struck by that because my reading of this entire thing was, boy, it's almost like you want a one-way street. You write a letter that says we don't have an agreement, and then you go to enforce it. Had your opponent sought to enforce it, you're saying, oh yeah, that he would have been right. Is that what you're telling us?
Yeah, I do. Yeah, there was an agreement, and an agreement can be enforced by either party if either party breaches it.
Has to be, right?
Yes.
Okay.
I'd
I
also-
actually have just a basic question, and in your brief on page 12, footnote 3, do you have that?
Yes, I'm pulling up
Yeah.
the page right now.
Right, in line 6, I did kind of wonder if the word defendant should be plaintiff.
Oh, yeah. There was.
Yes, you're correct. Where it says defendant was not seeking the liquidated damages provision was stating the law already
Yeah.
provided. That is a typo, and it should say plaintiff was not seeking the liquidated damages provision.
Okay.
It was stating the law
And
right.
do
I
you
apologize.
Do you have a case that states what happens on appeal when the appellant fails to state a standard of review? Because I'm not aware that we would ever apply an incorrect standard of review.
Well, I'm sure you're aware that the rules of appellate procedure require the appellant to state a standard of review. So the question is, what happens if they don't do that? There is a case that states that an argument not raised in a brief is ordinarily deemed waived. Commonwealth versus Clemente, 452 Mass 295, 2008, page 308, footnote 20. So the argument, I would argue, is waived. Now, you may be correct that the appeals court should not apply an incorrect standard of review simply because it was not
Right. It does, just because they didn't comply with the rules doesn't mean that we're then going to use that we get to use a wrong standard of review.
Well, I think that makes sense, but there is the standard.
It has
review. Right. I agree with
whether
you.
you think it or not, it has to be right. It has to be the case that we don't just get to say, didn't argue the standard of review, therefore we're making one up.
Right. And I don't think I can make one up. However, the standard review that I've advocated for, which is the clearly erroneous standard of review for the issue of whether the parties had an intention to be bound, that is the correct standard of review. It was used in the basis tech corp case. It's been used by the First Circuit for this same type of.
Oh, you can't cite the federal law. It's different than the state law on this subject.
You're
It's
right,
just
but I
flat out different.
Well, the federal law is different, but this court has applied that standard of review to the exact same issue with on a motion to enforce settlement that was held without an evidentiary hearing in basis tech corp. Same standard of review.
Let me see if there are any further questions. Otherwise, do you have anything further you want to say in your remaining 20 seconds?
Just that, I get the judge's determination there was an intention to be bound is correct. The interpretation of the contract as far as the amount owed is correct. Every word in the contract has to be given an effect. And if you look at my email, it says minus amounts paid by FRASCA third parties, as it says it separately for each different for the two time periods. And
all right,
talk about two different amounts.
We have your argument. Thank you both for your help.
We are once again live and on the record.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. However, all of our ordinary rules of argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case 2021 P0286 in the matter of a child. This case has been impounded. Therefore, we are not going to be using any identifying names or initials of any parties. With that, Attorney Walsh, we're ready to hear from you when you're ready on behalf of your client.
All right. Thank you, Your Honor. May it please the court. My name is Allison Walsh and I'm representing the appellant, the putative father, appealing the entry of the decree of adoption of the subject child by the Plymouth Probate and Family Court after the allowance of that appeal under Chapter 210 by the Supreme Judicial Court. It is our position that the decree of adoption should be vacated in this case because the putative father did not receive any notice of this proceeding. This is a case where the putative father, when he learned that mother had removed the child to Massachusetts from the state in which they were previously residing, Alaska, he did everything he could procedurally to protect his rights, and yet there were nevertheless a number of procedural safeguards that failed. In addition, due to the omission of some key information in court documents filed by the petitioners, the child was nevertheless adopted, even though there were parallel proceedings going on in Alaska regarding the custody of the child, and a putative father never received notice despite his participation in those proceedings.
So
And
if we could,
Yes, Ron.
there are a lot of issues here, and it's much appreciated. Let's start, I think, with the most basic of the issues. Why do you contend that notice was required under the Mass statutes?
Your Honor, firstly, I would say that notice was required because my client, the putative father, filed a parental responsibility claim in accordance with Section 4A of Chapter 210.
And does that, so how does that fit him within 210 Section 2?
Judge, it doesn't, well, I would say it doesn't squarely put him within Section 2, but I believe Section 4A in and of itself, by filing a parental responsibility claim, the parental responsibility claim effectively functions as an admission of paternity. So by filing that parental responsibility claim, my client effectively came forward and accepted paternity of the child, which would be the same thing that would be requested. A birth certificate is an acceptance of paternity. There are also other forms used in the probate court that's an acceptance of paternity.
Whoa. The birth certificate has to be signed by the mother, right? I mean, that's why I don't know if there's any law on what lawful parent is. We've tried to take a quick look and not really come up with anything. But what I heard in your answer is he doesn't squarely fit within those people who would be required to get notice under Section 2. Therefore, I go to 4A. The problem with 4A is, as your opponent has pointed out, 4A seems to be about something different than this situation. Whenever the mother of child born out of wedlock has surrendered the child in accordance with Section 2, or whenever the right of such mother to withhold consent for adoption has been terminated. Neither of those two conditions apply, right?
Understood, Your Honor. However, I think you have to go to the last sentence of that statute, which also of that section of the statute, which also says that effectively it encompasses all adoptions. It says no adoption shall be, or something to the effect of no adoption shall be allowed without compliance with this section. I'd also point Your Honor to
what does that mean? And perhaps it's a rhetorical question, counsel. I've tried to turn this over in my head, but you know, compliance with this section, it seems to me, brings with it the introductory sentence of the entire section, which says it only applies in the two circumstances I just identified.
clearly, Judge, I think we could all agree the legislature doesn't always write as clearly as attorneys or the judiciary would appreciate. That said, Your Honor, I would also note that the appeals court itself has addressed Section 4A within the context of a case that did not involve the Department of Children and Families in the past, the custody of a minor. I believe it was the 1984 case of the Massachusetts Appeals Court. That case, Section 4A came into play in that case, Judge, when the grandparents had filed a petition for adoption. So the department wasn't involved in that case at all. The mother had died, father had filed a parental responsibility claim, and the appeals court allowed his appeal and remanded the matter on the adoption back to the trial court. So I would suggest, Judge, that there's precedence in this case that it doesn't just apply to the department. I'm sorry, Your Honor.
That's all right. Under Section 2.
Yes.
Are you relying on the language? Are you relying on the idea that your client is a lawful parent?
Yes, Your Honor. I would say that.
And that is by virtue of his having filed the document with the DCF. And do you have any case or legal authority for the notion that a person who files such a document with DCF becomes the quote lawful parent of a child?
I don't have a case, Your Honor.
Okay, so let's take a hypothetical. Let's say that the stepfather here had sent a document into DCF. Would that have made him a lawful child? I mean, lawful parent?
A lawful parent, if he had filed a parental responsibility claim?
Yes.
Assuming that putative father had not?
Don't even get there yet.
Okay.
How can the act of, I'm just trying to probe your assertion that the act of submitting the document to DCF is enough to make one a lawful parent.
I think under the ambit of the statute, yes, Your Honor, it
So the
effectively
stepfather
says
would
that they're
have,
claiming.
so the stepfather would have been a lawful parent.
Right. There's no DNA testing or anything that's going along with this. It's basically somebody putting themselves forward and saying, I am taking parental responsibility. I am claiming this child legally as my child.
Well, at least financially.
Financially.
And then under Section 2, their consent is required before an adoption can occur. I mean, that's extraordinary, it seems to me. So somebody can file who maybe has no rights, and by filing, their consent is required, and they can get in the way of the adoption automatically.
I suppose if you're trying to square the two sections, Judge, I guess technically, yes, that would be correct.
Okay, so let's assume that we don't think it's that absolute. Okay, that just by filing with DCF is not going to necessarily, maybe a piece of information, a factor to be considered. I have to say the question I really had for you is about relief, which is maybe you're asking for too much too soon. In other words, we can't quite know yet whether he's a lawful parent. There was enough to suggest that he might be, but maybe a judge needs to determine whether he's a lawful parent, because there's been no adjudication of paternity. Before we can determine whether he was entitled to whether statute required that he provide consent to the adoption. Maybe there are some predecessor steps.
Certainly, Your Honor. I think, part of the challenge in this case is that putative father had started taking those steps in the Alaska court and had requested the DNA testing. It hadn't happened yet. So there were these parallel proceedings where he was taking the steps to try to prove his paternity. And because, he was involved in those proceedings, which mother was also participating in, he was going along, with the normal court schedule in Alaska, not realizing that this adoption was taking place in Massachusetts. And then once the adoption occurred, the Alaska proceedings were dismissed, denying him the ability to do that.
Right. So counsel, so I think I thought about this case in chunks, and The first chunk is your argument that statutorily he was entitled to notice. The second chunk you're getting to now, which is even if he wasn't statutorily entitled to notice, there were process points at play here as to which the mother or the adopting parent did not accurately say things to the court that caused notice not to occur, right?
Correct, Judge. Yes.
And as to this chunk, I'm interested in whether there are cases that will help us try to figure out if that's a basis to overturn the adoption.
So Judge, I would say that I think the best case I found on that is actually a US Supreme Court case, Armstrong v. Manzo from 1965, I believe. So it's going back a while, but in that case, Judge, it was an adoption that emanated in Texas. Under the Texas statute at the time, based on my reading of the case, a step-parent adoption could occur if there had not been payment of child support by the father in the 2 years prior. In that case, the mother and stepfather went to the court, averred that the Texas court averred that the father had not paid support for the prior 2 years, and he was not accorded notice of the adoption in line with the affidavit that they had filed. He later learned of the adoption, went through the appellate process, and the US Supreme Court, 4 years after the adoption occurred, reversed it and remanded it back to the Texas court. So not exactly on point. I mean, that was more
on what
probably
ground? On due process grounds.
due
I
process
assume, right?
grounds, right? Notice and an
So,
opportunity
but there
to be
the
heard.
father has established lawful rights, unlike your client.
Correct, Judge. In that case, their parties had been married prior. There was a divorce, so there was no question. in that
Right.
case.
So, I mean, so I'm having a hard time seeing how you get the relief of undoing the adoption on this record. It seems to me what you would at best be entitled to is perhaps a remand for determination of the factual issues concerning notice. And secondly, the factual determination regarding paternity.
Understood, Judge. And if that's what the court were to decide were appropriate, I believe I did ask for paternity testing as part of the relief. So if the court weren't willing to go ahead and do a complete vacation of the adoption decree at this point, my client would certainly be willing to submit to the paternity test. He's been willing to submit for 3 years. And he believes it's, that the child is going to come back after the
Right.
testing.
And then the court would that still wouldn't be the end of the story, because the court
Correct,
would
Judge.
still be needing to determine the best interest of the child.
Understood, Judge. Right. And that would certainly be an issue that would need to be tried at the trial court level. That would be our position.
So mother seems to be making an argument that where the father, putative father, failed to perfect his parental rights, that at this point he has slept on his rights. What do you say to that?
I mean, I think my client, hindsight's 2020 here. If he could do this all over again, he certainly would have signed the birth certificate or gone forward and tried to prove his paternity earlier. This is a situation where this was a situation where the parties were living together up until, about a year before all of this occurred. They were in a relationship. There had never been any issues. And suddenly he wakes up one day and realizes that his child has been taken to another state. At that point, Your Honor, I would say he did everything at that point, having not signed the birth certificate prior, that he could have done to try to preserve his rights. He went to the Alaska court. He requested the DNA testing. He filed the parental responsibility.
I mean, I understand, maybe it's just a slight overstatement, but he could have filed something in the Massachusetts courts, couldn't he? Knowing that that's where the child was, he could have filed something in the Massachusetts courts.
To that, I would say, Judge, that at that point, the children weren't in Massachusetts for a full 6 months. They had only been here a few weeks, and under the UCCJEA, which is the Uniform Child Custody Jurisdiction Act, Alaska would have been the home state, or that's the terminology used in that statute, the home state for the children at that time. So I would argue that Alaska was actually the appropriate place to hear the case. I don't know if Massachusetts would have been able to exercise jurisdiction at that point, Judge.
Well, did Massachusetts have jurisdiction to do the adoption?
That's an excellent question, Judge. I believe that the adoption was filed in June of 2018 and the children arrived in Massachusetts in or around April of 2018. I don't think the day that the petition was filed that there was jurisdiction over those children in Massachusetts. By the date it was allowed, December, yes, there would have been then because the children would have been there for 8 months. But the day it was filed, no, Judge, I do not think there was.
You haven't raised a question about that issue, at least that I've seen so far.
No, Judge.
It would have been, it's an argument that jurisdiction would have been lacking at the time the petition was filed and that somehow that would have significance.
As I'm sure you're aware, Judge, Massachusetts is the one state that's not a signatory to the UCCJEA. We sort of follow its spirit, but technically, Judge, that's not a statute that's in effect in this state. So that was, you know, it's a little bit of a gray area, I would say, as a probate practitioner.
All right. There are no further questions, I believe. We have your argument. Is there anything you'd like to just add? Your time is up.
No, thank you. Thank you, Your Honors. Appreciate your time.
All right. Thank you very much. Attorney McDonald.
Thank you, Your Honors. I represent the appellees in this matter. I would like to start first and foremost by indicating that it's our opinion that the putative father does not even have standing to go forward with this appeal. I understand that my sister counsel has raised the issue, the fact that we're here present today provides him with standing. However, with that being said, I would point the court to the case that we have cited, which was in Ray Bonney. Again, at the time of the child's birth, the mother was married to another man and a putative father was named. Obviously, the putative father, there was some indication that he had conceived the child. The putative father in that case had never established paternity. Similar to this situation, there was never established any paternity. The court ended up under Section 3 of 210, terminated the putative father's rights, and then the putative father appealed, indicating that you can't terminate rights that don't exist. I would suggest, Your Honors, that this case is very similar to the In Ray Bonney case. The court also indicated
So
that—
you're saying he has no rights at all. He has no standing, even if he's the child's biological father.
Correct. And I believe, as Your Honors had indicated themselves, is that if there's no adjudication, there's no voluntary acknowledgement, there's no signature or name on the birth certificate, there's no DNA test. I think similar to what Your Honors had mentioned is that any person could claim that they are a relative, a putative father, and then file to establish paternity, which again is not the standard.
Well, maybe hypothetically, but his name is on the birth certificate. The child has his last name. He lived with this child, based on the evidence that we have, for years. And the notion that he has no rights under those circumstances sounds very foreign to me.
And I would suggest, based upon the record that your honors do have in front of you, is that the last time that he had any type of overnight parenting time, I will call it, was December of 2017. The mother and the children left Florida, where they were residing, for a period of 3 to 4 months where he never sought the children. They went to Alaska for a short period of time. They resided together, and then mother resided with her now current husband.
Why is this relevant to the question of whether he has standing as the putative father under the circumstances here?
Because
there are a lot of facts that you put in your brief that I struggled to find out why they were relevant to the question of whether he should have received notice of this particular proceeding before his rights were terminated. And those are some of them.
I understand that, Your Honors. However, again, as indicated, I'll go back to the In Ray Bonney. There was an issue of whether or not who the putative father was. And that case specifically stated, as a matter of due process, an unmarried putative father has no absolute right to notice and opportunity to be heard before a child is adopted. The putative father here relies upon a complaint to establish paternity and also his parental responsibility claim to demonstrate that he, in fact, tried to or attempted to establish paternity in those two respects. However, I point actually to the case that my sister counsel has referenced in her brief, which was the adoption of Alex, which I would suggest is very similar to the case at hand as well. In that situation, the putative father there filed a complaint to establish paternity after the child was adopted. The mother had subsequently married her husband. They filed a petition for adoption. The court allowed it. Prior to the adoption being allowed, the putative father filed a complaint to establish paternity. It's unclear, unfortunately, in the case that we have, is why his petition under Section 11 was denied. The single justice ended up denying his petition to move forward on his appeal, and subsequently denied the complaint to establish paternity and dismissed it as moot.
My colleagues may have other views about this, but I'm very interested in what happened in this case. And I'm particularly interested in the following. You filed, on your client filed in June of 2018, a petition for adoption. That petition itself indicates, I believe, a lack of knowledge of any other existing lawsuits regarding the child. The record we currently have in front of us indicates that the mother had knowledge of the Alaska proceedings by August, and in fact had retained counsel in Alaska who had appeared. That fact, the fact of the Alaska proceedings, was never disclosed to the Massachusetts probate judge. Is that correct?
And I would suggest, Your Honor, that based upon the actual documentation that is included in the record of appendix, is that she was actually not served with the actual complaint to establish.
You did not
paternity
answer my
until
question,
December 7th.
counsel, and you're going to have to answer them, I'm afraid.
Sure.
In August, okay, in August, did someone appear on mother's behalf? Is that what the record shows? You don't have to answer the first question, but you need to answer the second. Doesn't the record indicate that someone appeared on mother's behalf in the Alaska proceedings?
I believe her attorney, yes, Your Honor.
Okay, all right. And that fact, the knowledge of the Alaska proceedings, was never disclosed to the Massachusetts probate court before something happened in December that terminated the father's rights, correct or not?
To the best of my knowledge, that is correct, yes.
Isn't that a problem? Isn't that a problem? For one thing, isn't your colleague right that there is a rule of the trial court that it was supposed to be disclosed?
Well, I would suggest, again, this is the petitioner on behalf of a step parent. This is the petitioner on behalf of mother's husband. Mother's husband is not participating in any type of custody proceeding involving the minor child. I would suggest that the trial court rule is not applicable in that situation because the stepfather is the one who is actually proceeding forward with the adoption. And again, it goes back to whether
isn't he charged with the mother's knowledge under these circumstances, whether or not he knew actually? How can he not be charged with the mother's knowledge? He's trying to terminate the father's rights and become a parent that co-parent with her.
I would suggest, again, this comes back to the issue of whether or not he's even deemed a lawful parent. And I have found—
No. You were talking about the stepfather. What you were arguing to us was a suggestion that the stepfather somehow did not know what the mother knew about the Alaska proceeding. And my question is, isn't he charged with the mother's knowledge under the circumstances?
Judge, so I'm assuming what you're indicating is whether or not knowledge is being attributed to knowledge that the mother may have to knowledge of the husband. However, the rule specifically states is whether or not he has participated in any custody proceedings.
All right. What do you? I mean, I think we can agree that the purpose of these requirements is to ensure that the trial court has all the information that might be relevant or that would bear on making a sound determination as to what is in the best interest of the child with respect to the adoption petition. I think we'd all have to agree to that, correct?
That is correct, Your Honor.
And in that context, knowing that, then it seems that we really can't dispute that it would have been beneficial to the trial court to have known about the Alaska proceeding. So I see that Justice Henry had a question.
Well, I'm just trying to understand if, assuming that the putative father is the biological father and that he acted as a parent for a few years, I take it your position is he does not have a right, whether it's statutory or constitutional, to notice of a proposed adoption by another person. Is that right?
That would be our position currently. And here are the reasons, therefore, is because this child was born in 2013. Allegedly, he's been a father. Again, we would obviously disagree with that situation. He had up until today to establish those rights, at least in the interim from 2013 up to the birth of the child, up until 2018 when he filed his complaint to establish paternity. There's no indication in the record that he's ever paid child support. There's no indication on the record that he's ever taken care of this child. There's no indication that he has done anything to affirmatively take those steps to secure his quote unquote parental rights. In addition, he admitted on the record that the last time that he had any overnight time with the child was in December of 17.
Is your argument that these things go to determining whether someone is a quote lawful parent as
That is-
used in section 2?
That is correct. Or again,
Okay,
even-
so where, what, does that come from a case?
as far as the affirmative steps,
No, as to
Yes.
has anyone interpreted? Is that a defined term in the statute anywhere, lawful parent?
I do have it from, again, secondary sources about what is deemed a lawful parent or a lawful father.
Okay, what about a case?
I do not have a specific case. However, it does state from the petition of revocation of judgment for adoption of a minor, states that waiting.
What's the site?
I may just have 1 minute, Judge. And again, just to state, it does say that waiting 17 months after receiving notice of adoption was a deliberate litigation strategy, and the grandmother was not acting in the best interest of the child. So again, it is, Your Honor, 393 Mass 556. And that was decided in 1984.
And that says that's going to tell us something about what a quote lawful parent is?
It is not, just as far as.
Okay, so that's what I was asking. I was asking, is there any place in a statute or a case where we've said, what does it mean to be a lawful parent for purposes of section 2?
I would suggest, Your Honor, that the statute does in itself, because of the fact, again, a lawful parent, just in general, you would have to acknowledge paternity and be adjudicated the father, which none of this is present. So that's why the statute specifically says.
So,
only the mother
I mean,
born out of
what we
wedlock.
have on our record is that the putative father filed a petition in Alaska, a paternity petition, before the filing of the adoption complaint. If that had been ruled on in his favor before this, then you would agree that he would be a lawful parent entitled to notice and provide consent before the adoption in Massachusetts, correct?
That is correct, Your Honor. But no,
Okay,
that is correct.
so the only difference between that set of facts and this one is that the Alaska court had not yet ruled.
In some respect, yes, Your Honor, yes. Whether or
Okay.
not, again, whether or not it's in the best interest of the child is another completely different.
Totally different question. We're not even getting there.
And I would say, again, just from the record, from the testimony that the putative father acknowledged, just to put on the record that he admitted in 2012 that he was sleeping in a different room with his mother. He was unsure when the child was conceived. He was unaware if the mother was dating any other people. When he
Right,
child
so he
support-
may not be able, that paternity test may not do him any good.
Correct.
We get that point.
And you have an argument that even if you get past it, that it's not in the best interest of the child. We understand those. We're talking about notice. And with respect to notice, I'm looking at a document which I believe you filed in August of 2018 called a motion to waive notice, in which there are two pieces to it. The first is your reference to the law, in which you ask that no notice be given to any of the three fathers of the three children. And the second is an affidavit of your client. Now, let me ask you, if on the assumption that you knew at that time of the existence of the Alaska proceeding, is it your position you didn't need to disclose it to the court?
Well, Your Honor, as far as that is concerned, with the affidavit, the court was aware of who this alleged putative father was. The court may have made its own decision sua sponte that he did not need notice at that point. Maybe the court indicated there was a decree dispensing with notice at that point, given.
So you haven't, again, counsel, you haven't answered my question. My question goes to the fact that there's no disclosure in this document of the existence of the Alaska litigation. My question was, on the assumption that you knew about the Alaska litigation as of the time this was filed, I believe it's August 9th, 2018. Is it your position you didn't need to disclose the existence of the litigation?
I'm not suggesting that, Your Honor, no. However, given the fact that, again, under the Massachusetts law, the mother has full legal rights to this child under 209C. There wasn't, again, this is just a person who's indicating that he's just the biological father, period.
And he's done what he was supposed to do, at least you would say late, tardily. But by the time this was filed, he had done what he is supposed to do to establish his paternity. He filed a lawsuit in the jurisdiction which had jurisdiction over the child.
And I would suggest again that there was no substantial relationship to demonstrate that he should have even been able to file that. The whole reason about the issue with the Alaska and Massachusetts courts was the issue of jurisdiction, because again, mother had full legal rights under 209C because nothing had been adjudicated. So to suggest that an individual who is claiming to be a biological father, when there's no indication that he is the biological father, can come and interrupt a family household is upsetting. And that's a precedent that this court would be setting if this were to be allowed moving forward. And I would just like to ask, and I know that our time has expired. I just would like to put this on. I said, what we are suggesting here is that if this appeal were to proceed forward, that we would allow an individual to come in years after he had noticed that he could potentially be a father to a child, interject and disrupt the family years after the fact. That could be a dangerous precedent to set forth. In weighing the equities, the father allegedly knew that the child could have been his. He chose not to obtain a DNA test. He chose not to acknowledge paternity. He chose not to be on the birth certificate. He chose not to pay child support. He chose not to have a substantial relationship with his alleged child, and also chose to wait the 120th day of the appeal process to file an appeal. I would suggest.
So for this judge, counsel, it's a dangerous precedent to conclude that you can file a notice to a document that asks to waive notice and not disclose the fact that someone whose name is the child has as a last name has filed a lawsuit in the jurisdiction that had jurisdiction. That's a dangerous precedent too.
Where again.
Okay, we're not going to. Your time is up.
Thank you.
That wasn't a question, and you don't need to answer it. So let me look.
I just have one question because I just wanted, I might have misunderstood what you said, counsel, but are you saying that the court here that granted the adoption did know that he existed?
Yes, he was in an affidavit provided in support.
Oh, because he was in the, okay, all right.
All right, thank you. It's an interesting case. We've been helped